I'll tell you later.
Okay, good morning. Welcome to docket number 230832, the application of Connecticut Water Company to amend its rate schedule. My name is Chairman Marissa Gillette. I'm joined in person, almost said virtually, by the Vice Chairman Jack Bukowski and Commissioner Michael Karen to my left. This is the first day of evidentiary hearings in this matter, so we do have a couple of administrative matters to kick us off. Other mornings, we will begin promptly at 10 a.m. and can get right into it, but I do want to take care of a few administrative matters before we begin, starting with a request that folks enter their appearances. I know that we have done this at earlier stages in the docket, but since this is our first time in person together, it would be helpful to have at least one member of the parties or interveners if present to have entry of appearance. As a reminder, this still is required according to the NOP to be done in writing into the docket. So this is just a formality and a request to meet you face to face. So Attorney Bogan, I'm going to start off with you and then ask attorneys representing other parties and interveners to approach the mic after that to enter an appearance this morning. Attorney Bogan. Thank you. Welcome. Who else is here to make an appearance, please?
Morning, Chairman. Oh, it is on. Tom Wheel for the Office of Consumer Counsel. The other staff attorneys that will be appearing in this proceeding are Allison McCorney and James Talbert's legal.
Thank you. Okay. Hi, Attorney Richter.
Good morning. Joel Dichter of Dichter Law on behalf of the Heritage Village Masters Association.
Thank you, sir.
Thank you.
Director Lopez.
Good morning, Chairman Gillette. Thomas Lopez on behalf of the Office of Education Outreach and Enforcement, along with attorneys Kim White and Brittany Wyman. Thank you.
Thank you. Any other Attorney Wright, please.
Thank you, Chairman. Good morning. Vice Chairman Bukowski, Commissioner Karen. John Wright on behalf of the Attorney General.
Thank you, sir. Anyone else who would like to enter an appearance at this time? All right, thank you for indulging us so I can put faces to names. Appreciate that. Okay, we had a pre-hearing procedural conference in this matter, so I will not revisit some of those matters, but we are live streaming, so if you have folks back at your home ranch who report any difficulty hearing or interruption in the broadcast, please feel free to let us know, as it is our intent to live stream the duration of the public portion of this broadcast. Of course, if we have to enter into confidential session for any reason, that will not be live streamed. But I don't believe we're expecting that at this time. We do have our court reporter with us, so I recognize many of our witnesses. Others, if we can just make sure at all times that the light on your microphone should be lit up green when you're speaking. And some of the mics on this table are more temperamental than others, so that I may have to interrupt and ask you to pull it closer to yourself at some points in the proceeding. There are name placards. We should have a name placard for all witnesses and folks that intend to cross-examine. So if you do not locate that on the bench over there at any point, please let our case coordinator, Mr. Bumpin, know, as the name placards do help our court reporter to keep the records straight. Okay, let me ask the parties and interveners if there are any administrative matters before we get underway. Attorney Bogan, and you can stay seated, sir, unless you'd like to stand.
I was taught to stand when you speak. I attribute that to former Consumer Counsel Jim Meehan. And thank you for the admonition regarding the microphones. You'll be pleased to know that Ms. Lupoli also sent me an email saying, turn on your mic. Couple of things. Number one, the company during the pre-file, the scheduling conference did indicate that we would supplement our filings. We did do that yesterday, so there were several that were made. Secondly, with regard to the estimated cross-examination times, for the most part, I had indicated 30 minutes for each of the outside experts. After looking at the materials over the weekend, that's not going to be necessary, so I'm just going to reserve the right. With the exception of Mr. Dunkel, I'll leave that at 30 minutes. And well, I'll leave that for a moment. There are no specific dates for the witnesses. I understand the chair's desire to roll sequentially and just go from one panel to the other. Because a number of our experts are out of state, we're going to do our best to comply with that request, but ask that you we beg your indulgence in case we do have a blip. We're trying to guess when we think particular witnesses will go on, but if we happen to go faster, we can notify the witness, but it may be a little difficult for them to get here, but we will certainly endeavor to comply with your requirement. Finally, along the lines of the schedule, the OCC has indicated 20 minutes for direct testimony when Mr. Dunkel appears. That was the first time I had heard of that when we got the schedule on Friday. That's a little bit unorthodox in my experience. That's the purpose of pre-filed testimony. I would have thought they would have filed a motion because essentially I think they want to rebut our rebuttal, but I'm not objecting to it, but I'm curious what the OCC has in mind with regard to that scheduling placeholder.
I'm sorry, just for clarity of the record, which page of the agenda are you referring to?
Uh, 15.
You're not entering an objection at this time.
No, Chairman Gillette.
Thank you. Anything further?
No, I do not.
Okay, thank you. Are there any administrative matters from other parties or interveners this morning? Attorney Wheel.
Thank you. I just wanted to address the company's inquiry. We do plan to provide some direct testimony from Mr. Dunkel. It is responsive to some of the issues that were presented by the company's rebuttal testimony. I'm not aware of any requirement, statute, regulation, or standard for PURA that would require a motion to present direct testimony. If the authority would prefer that we file a motion requesting it, we certainly would. There are some documents that Mr. Dunkel intends to refer to during the testimony. I can file some correspondence referencing those to give the company a sense of the areas that Mr. Dunkel wants to cover, if that would be helpful.
Okay, let's accept your proffer of filing the documents as correspondence at this time. We do not have any precedent that I'm aware of that requires a motion for any party to request a direct testimony or opening statement. But since there is not a formal objection before us right now, I will leave it there. Anything further?
No, thank you, Chairman.
Okay. Any other administrative matters, please? Is this our deep team? Attorney Anaouiji? Okay, I've just, we're taking, I took appearances. So just for, you've already entered it formally and just want everyone to be aware of who everyone is. Everyone, this is Attorney Anaouiji with Deep. Great. Okay, sorry, I left off one housekeeping matter. When I mentioned the YouTube live broadcast. Even when we are on break, the mics are live. So please, if you have conversations that you do not intend to share with others, I'd ask that you step out of the room. This will likely be the only caution that I offer. So please keep that in mind. Okay. Last call for opening administrative matters. All right. I have one more, but I'll take that in just a moment. Let's move to the swearing in of witnesses. So Attorney Bogan or Attorney Chen, whomever like to introduce your panel, I'll swear them in because I think not everyone was sworn in at our last event, and then we can move to adoption of pre-filed materials.
Very good. With us today, we have Craig Patla, Rose Gavrilovic. I knew I'd get
That's why I make you do this.
that. David Peeling and Troy Dixon, if you would all rise so you can be sworn in.
Okay. If you could please raise your right hand, I'll administer the oath at the conclusion of the oath. If you could please say, I do. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury.
I do.
Okay, thank you. Attorney Bogan, could you please have the panel adopt their pre-filed materials?
I will. Starting with Mr. Patla, could you please state your name and position with the applicant?
My name is Craig Patla. I'm president of Connecticut Water Company.
Ms. Gavrilovic?
My name is Roseanne Gavrilovic. I am the Vice President of Service Delivery with Connecticut Water Company.
And Mr. Peeling?
My name is David Peeling, Vice President of Engineering for the Connecticut Water Company.
And finally, Mr. Dixon.
I'm Troy Dixon, Vice President of Regulatory Affairs for Connecticut Water.
Mr. Patla, did you prepare or cause to be prepared certain pre-filed testimony on behalf of the applicant in this proceeding?
I did.
Do you have any changes, corrections, additions to make to that pre-filed testimony?
I do not.
And do you adopt that as your sworn testimony in this proceeding?
I do.
I almost forgot to ask. It is true and accurate to the best of your knowledge.
It is.
Ms. Gavrilovic, did you also prepare certain pre-filed testimony on behalf of the company in this proceeding?
Yes, I did.
Do you have any changes, corrections, additions to make to that filing?
No, I do not.
Is the information true and accurate to the best of your knowledge and belief?
Yes, it is.
Do you adopt that as your sworn testimony in this proceeding?
I do.
Did you also have occasion to prepare or cause to be prepared responses to certain interrogatories on behalf of the company?
Yes, I did.
Do you have any changes, corrections, additions to make to those responses?
I do not.
Is the information true and accurate to the best of your knowledge and belief?
Yes, it is.
And do you adopt that as your sworn testimony in the proceeding?
I do.
Mr. Peeling, did you also prepare certain pre-filed testimony on behalf of the company in this proceeding?
I did.
Do you have any changes, corrections, additions to make to that information?
I do not.
Is it true and accurate to the best of your knowledge and belief?
Yes, it is.
You adopt that as your sworn testimony in the proceeding?
I do.
Did you also have occasion to prepare or cause to be prepared certain responses to interrogatories propounded by the authority and other participants in this proceeding?
Yes, I did.
Is the information true and accurate to the best of your knowledge and belief?
Yes, it is.
You have no changes or corrections to make?
Not.
You adopt those responses as your testimony in the proceeding?
I do.
Finally, Mr. Dixon, did you also prepare certain pre-filed testimony on behalf of the company in this proceeding?
Yes, I did.
Do you have any changes, corrections, additions to make to that filing?
I do not.
Is the information true and accurate to the best of your knowledge and belief?
Yes, it is.
You adopt that as your sworn testimony in the proceeding?
I do.
Did you also prepare or cause to be prepared responses to certain interrogatories in the proceeding?
Yes, I did.
Do you have any changes to make to any of those responses?
I do not.
Are the responses true and accurate to the best of your knowledge and belief?
Yes, they are.
Do you adopt those as well as your sworn testimony in the proceeding?
I do.
With that, Chairman Gillette, the panel's available.
Thank you. And I understand that Mr. Patla may have an opening statement. I just have one more housekeeping matter about late file exhibits that I'd like to go through. As noted in the schedule, any late file exhibits issued today through Friday have a due date of February 2nd. The one exception is the late file exhibit that I'm going to proactively ask for now, which is the late file exhibit the authority requests at every hearing. So this will be known as late file exhibit 1. And although it's being issued today, its due date will be the February 5th, which is the due date for the other late file exhibits. So if you're familiar with other authority rate cases, it's our common practice to issue a late file exhibit that generally is intended to capture any updates or errors that are identified during the course of the proceeding. I do want to read verbatim the prompt, as it is very specific. And the prompts for late file exhibits, as folks know, will be uploaded into our case management system. We can't always capture the level of detail in the prompts in the case management system, so we'll reflect it here in the record. So for late file exhibit 1, the company is to provide a list of capital projects identified in the rate application as may have been amended with authority approval that are in service as of the close of the evidentiary record, inclusive of any adjustments for errors or information uncovered during the hearings. So in other words, if there are errors or updates to any schedule that was filed with the authority during the course of this proceeding, we'll ask that all of those schedules be refiled as late file exhibit 1. I'm happy to reread that or answer any clarifying questions but before we continue with the
If I may
day,
have 1 second.
please.
Thank you, Chairman Gillette. I have nothing.
Okay, thank you. Then that will be entered as late file exhibit 1, and we will move on with numbering from there. We also sometimes have read-ins, which will be numbered using letters. So we'll ask Attorney Bogan and Attorney Chen to help me stay honest in these read-in and late file requests, as that seems to have worked okay in previous proceedings. So without further ado, Mr. Patlow, I want to welcome you and invite you to provide your opening statement, and then we will turn to cross.
Thank you, and good morning, Chairman Gillette, Vice Chair Petkoski, and Commissioner Karen, as well as the other stakeholders and interested parties to this proceeding. As stated earlier, my name is Craig Patlow. I'm a 34-year employee of Connecticut Water Company and its current president. It's my privilege, and I'm humbled to be in a position to lead this organization of dedicated professionals as we strive to meet our mission of delivering life-sustaining, high-quality water and exceptional service, while all the while protecting the environment and enhancing our communities, and as well providing a fair return on the necessary investments. Water touches everything we care about, truly does. It's a necessity as an elemental human need. Public health, safety, basic human activity in the form of drinking, cooking, bathing, sanitary, or even fire protection are reliant on the provision of potable water to homes and communities. We are all the stewards of that necessity, all gathered in this room. The company, certainly, the commission, the Office of Consumer Counsel, the AG's office, everyone. We all have that obligation to the people, the people. Good enough or just in time cannot be our way. We've learned through the many storms that we've faced over the last 12 years, I suppose, of the importance of water and that continuity of provision. The stakes are high. Reliance and confidence in the availability of water should be unspoken, almost taken for granted, and most times it is. But therein lies our quandary. We need to ask the people, the customers, to pay for that reliance and confidence. And in the circumstance of this docketed proceeding, to pay a little more for something that is in large part taking for granted or ordinary. That ordinary aspect of water availability belies the extraordinary aspects of what it takes to deliver on that proposition. What's behind that delivery of potable water? 24/7 operations and maintenance, certainly. 1,800 miles of water main in our case, 12 reservoirs, 25 treatment plants, 200 wells. The challenges are every day and they're before us. Large investment around those operations to meet the needs of yesterday's, the todays, and the tomorrows. And dedicated professionals. Employees regularly say to me, who have a career's worth of other experience, say this is the first time they feel like they're doing something important. And you know what? They are. I recently heard from a colleague that kicking a utility that's in for a rate increase is politics 101. And that may be so and likely is. However, we collectively cannot afford to be political as we examine the facts put before us today and in the coming days. It's hard. It's hard. We know it. Our collective obligation has a much higher call because our customers depend on that availability of water and deserve the transparency of the content of these proceedings to ensure that our ask meets that test of prudency. They deserve it. As we sought input from the public in the course of this proceeding, the common theme we heard was, we don't like a rate increase. That's a good company. Or now is not the time for a rate increase. We get that. We understand it. But as well would submit that there's never a good time for it. In my 34 years, I've not heard, now would be a good time to come in. Not heard that. But the necessities remain. It is the most critical of utilities. The sustainability, the stewardship of our critical utilities through prudent investment and right-sized operational and maintenance costs should be, as Governor Lamont says, not a dime more. And we get it. We agree with that. That is why we are here today, not as adversaries, but as an open book. You have my commitment as president of the organization, and we've talked often about this, the openness of our book to you all, so that we may arrive collectively at that best decision for our customers who demand it and deserve it. We look forward to these next few days as we look to tell our story, demonstrate who we are, what we're about, so that we can collectively arrive at that outcome that our customers deserve. Again, I thank you, Chair, for the opportunity for this opening statement.
Thank you, Mr. Patla. With that, we will begin our scheduled cross-examination, and we're going to begin with authority staff. And I believe we have our water engineer, Maria Jewell, to begin our cross-examination, please.
Thank you, Chairman Gillette, Vice Chairman Butkowski, and Commissioner Karen. Good morning, everybody. I would like to refer you to response to interrogatory RRU 66. This is about acoustic monitors.
I'm sorry, Ms. Schul, was that RRU 66?
Yes.
Thank you.
The company purchased 9 acoustic monitors, installed 109, but only paid for 9 monitors. And the cost was $21,418. So one acoustic monitor cost close to $2,380. My first question is company planning to install more acoustic monitors in their system, or this was just one time deal?
Looking at the information that we gain from the acoustic monitors, balancing that cost with the benefit to our customers by installing them. We'll continue to evaluate the need for the acoustic monitors as we move forward. For now, we don't have plans to install any additional monitors in 2024.
Are these monitors portable? Can you move them from location to location, or once they are installed, they must stay in the same location?
They are fixed monitors and they remain in the same location.
And what is lifetime of these monitors?
The lifetime varies with the with the generation of the monitors. So the battery life is 10 years. The initial monitors that were installed in 2020, or a portion of them, do not have, we cannot replace the batteries in them. The more recent ones installed in 2023, and I will verify to ensure that there are none in 2020, but those monitors, you're able to replace the battery and they have a much longer life.
Who is reviewing the data? Connecticut Water employees or somebody else from outside?
We have our consultant reviews that data, and they notify us if there is if we do not receive a signal for 7 consecutive days. And then if that's the case, then we review and make a determination on what the problem is with that monitor.
What are the other ways of discovering leaks that the company is using in the system? Because you have other ways.
Yes. So we have our leak detection program. We have staff who is specifically assigned to do leak detection all day, every day. We monitor our production trends. We look at a 25-month span of production data, and based on that, we can monitor the trends. So we do that from the office, but we also forward that information to our operators who are out at the facilities every day, and they have that feel for what's happening in that system. So collectively, we monitor that data and identify areas that we need to do further investigation.
What is more expensive, acoustic monitors or your average or regular leak detection program?
I would say the acoustic monitors are more expensive. However, they are fixed in those systems where we believe we can gain the most information from them in order to deploy our resources to a targeted area. It's very difficult if we see production data that shows that there may be an issue in a small system. It's very difficult to target where exactly to dedicate those resources. So doing a leak detection survey takes a lot of time, depending on the conditions in the system. If there's ledge or if it's sandy soils, it could be harder to detect leaks. So we believe that a combination of the monitors plus our data monitoring and our leak detection program is the best way to address leaks.
Thank you. A response to interrogatory RRU 70, please. It's Reynolds Bridge Wellfield still active?
I apologize. You said RRU 70?
Yes,
Just a minute, please.
that's about contamination in the area.
And what's your question relative to Reynolds Bridge?
Yes, I would like to know if this well field is still active. And I believe that this well field was contaminated by ethylene dibromide, so EDB in short.
May I answer?
Oh.
Reynolds Bridge is still active and we do filter there for EDB removal.
What is the company doing to eliminate EDB from the area? Is it possible to eliminate this contamination?
The contamination on the Reynolds Bridge site actually emanates from an adjacent site that was at one point occupied by the town garage. They have conducted a remediation process there to remove that. And this is back in the 90s that this was completed. But we continue to move our water through filtration there to remove that EDB. The trace amounts yet still there.
Okay, so can Connecticut Water be responsible for the contamination that is in adjacent area, or this is all on shoulders of the town?
We are not responsible for the contamination.
Mhm.
There was litigation associated with that. But as you know, we are responsible for the quality of the water, and we are subject to what that contamination is and remains.
Are you in contact with the town and talking with the town to make sure that this contamination is not impacting your system?
That was all adjudicated during the lawsuit of the early 90s. And that site is no longer active by the town. So there is no, we specific to the situation at Reynolds Bridge, there's no further activity with the town other than our normal day-to-day discourse with them.
Thank you. Regarding PFAS, and this is also in response to RRU 70 and 71. It seems like Connecticut Water discovered contamination with PFAS in Mansfield, Ellington, and Avon. This is in RRU 71. My first question is Connecticut Water expecting to find more contamination in the area, or is convinced that all the areas are now found?
RRU 71 is specifically referring to locations where we're seeking SRF funding support to address the PFAS we've discovered. We have PFAS at many more sources than just these three. My pre-filed testimony mentions we had 40 raw water sources that we discovered PFAS, and subsequent to that, we continued testing through 2023 and into 2024, all of those over 200 wells Mr. Patla mentioned at the beginning, building a database to see where it's present. And it is prevalent throughout the state, like most water systems are discovering.
Okay, now Connecticut Water requested 9,600,000 from Drinking Water State Revolving Fund, subject to check. I just added those numbers 1,007.1 million and 1.5 millions. Where is the application? What is the status of those applications that Connecticut Water submitted to DPH?
The specific projects listed in RRU 71, there has been some change in SRF approach subsequent to when we prepared this response. The Egypt Road treatment plant continues in the design process. We have an application under review with the SRF program. In place of the Birchwood Heights program, we're now pursuing the Green Springs project as an interconnection to address elevated PFAS in Madison. And the Avon Well Number 3 project, we've removed from SRF approval process because we needed to expedite that project. We needed to get that construction started this year based on the levels and the criticality of that source. And we didn't have enough time to let the full SRF approval process play out. We also added Gallup Well Number 1 as an additional project that is in with SRF as well.
So regarding the Avon Well Number 3, this $1,500,000, is the company going to pay for PFAS removal, or because I understand now you don't have this application in the DPH?
The Avon Well Number 3 source is critical to the water supply in that system. That's one of 2 sources we discovered that were over the DPH action levels. And we shut that source down immediately to make sure we weren't sending PFAS out into the distribution system. We need to get that source reactivated and available. So we're pursuing this as a capital project for filtration system to remove PFAS. As all of these projects will be, they will all be capital projects. SRF gives us the opportunity to recover some portion of that with the terms and specifics of that to be determined through the SRF application process.
Right, how long it's gonna take you to reactivate well number 3?
We expect to have that online by the end of 2024.
Thank you. RRU 72, please. First, housekeeping. In the 4th paragraph from the top, which starts in March 2023, there is almost by the end of this paragraph, it says that have a combined hazard limit of 1. What is the unit? Is this one number or is it a unit over there?
It is just one. There is not a unit associated with the hazard number.
Okay.
It's unitless. It's a formula for, it takes into account 4 PFAS compounds: Gen X, PFBS, PFNA, and PFHXS.
Okay, thank you. Connecticut Water has a deadline on October 24th to develop lead service line inventories. I know you have some inventory of lead service lines, but do you have all lead service lines identified or not yet?
We do not. And that inventory is really to determine what we know and what we don't know. So determining the materials for the service lines. So there are service lines that where we know that they are copper, or we know that they are lead or galvanized. And there are others in our system as we've acquired other systems through the years. Some records were better than others. So we've been working with our consultant, Hazen, to identify those areas where we have unknowns. And as we continue to move forward, we're working to further identify as many of those unknowns as we can before that October of 2024 deadline, when we will submit that entire inventory.
Okay. Do you think that you can get, or is company thinking that can get support not only from the state, but also on federal level regarding removal of lead from pipes or PFAS?
I believe that the federal government has worked with the states in order to be able to allocate the funding. That's the mechanism, the DWSRF program is the mechanism by which the federal government is able to provide dollars for projects such as lead service lines. We do have an application into the state DWSRF program for lead service lines as we move forward. So that we are planning to seek funding associated with the work for lead service lines.
So is this going to be sort of like a low interest loan, or is this going to be just money given by state for?
It's a combination. The state, the DWSRF program has certain subsidies that they will allocate for a project, and then the remaining portion is the loan portion. The lead service lines, the PFAS, those are considered emerging contaminants. So they do have a category where they have a certain bucket of funding associated with that, which is why we wanted to get our application in as soon as possible for that, so that they, as they are allocating those dollars, Connecticut Water has our application submitted. I believe there's a fixed amount that is allocated for those specific items. So if the dollars are used up for the emerging contaminant portion, which may be a higher percentage of subsidy, then if those funds run out, they will just give the subsidy for a traditional project. So there will still be subsidies either way.
Thank you. A response to interrogatory RRU 73, and we will be talking about attachment. So this is DPH sanitary survey reports for years 2000, starting in 2021 and ending in 2023. First question I have is on page 52 of the sanitary report.
Can you clarify which exhibit? That is?
That's RRU 73 Exhibit 1, 2021, page 52.
Okay.
So under minor deficiencies, the report states that well number 5 is not properly located, or the distance between well number 5 and existing septic system is less than required by regulations. What is the status of this issue as of right now?
That I don't have the answer to right now, but I would be able to get it for you to do a read-in if that's possible.
Of course. So we have our first read-in A. And Ms. Jewell, can you please briefly restate the question?
A1, well number 5, distance from septic system.
Thank you.
Page number 100, please. This is Westchester Village System.
Madam Chair, can I have 1 second?
Yes.
Thank you. I just wanted to confirm we would be able to get it.
As a read-in. Okay, thank you. If not, at the end of the day, we can translate it into a late file if needed.
Thank you.
The atmospheric storage tank for Westchester Village system was up for inspection in 2021. And I could not find in the Connecticut Water response to the survey that the tank was inspected. It was just a statement that the Connecticut Water was sent to DPH update when the tank was inspected. Was the tank inspected?
If you would give me just a moment, I believe we have the tank inspections in another interrogatory. I can
Okay.
refer to.
Yes, I was looking at this and I could not find it.
Okay,
That is a list like 3 pages, but maybe I overlooked.
thank you.
So this was in RRO 117, Exhibit 1, right? Maybe another read in if you don't have it.
Read it.
Yeah.
Read it.
Yes, I believe that would be the best way to approach it. Thank you.
Okay, so read-in B was about, it was the,
Atmospheric storage tank inspection for Westchester Village system.
okay,
Um, On page 124 of the report, this is sound view system. There was significant deficiency. The cap on well number 11 had crack on the lower section near the vent. The question is, was the cap replaced? Because this was DPH recommendation, and this was in 2021. Your report states that it will be replaced, but it doesn't say was replaced.
I'd like to request a read-in for that item also.
Okay, so this is sound view system, cap replacement, well, number 11.
Read and see.
Regarding interconnection between Connecticut Water and Yukon system. In 2021, the survey report says that you did not have meters installed on these interconnections. Is there a reason why meters were not installed? And are they installed right now?
There are meters installed at the interconnection point
Yeah.
of the university, yes.
Okay, thank you. No more questions about it. Regarding 2022 sanitary reports, SDC water system, that's page 38.
Okay,
It seems like there is a violation for large drainage swell carrying stormwater to the pond that is within the well sanitary radius, and this is well number 1 and 2. Is this violation corrected, or what is the plan? What the company has? What kind of plan is there to correct this violation? Now, in DPH response, I'm sorry, in Connecticut Water response, that's on page 42, Connecticut Water states that the stormwater drainage was upgraded by the town of Voluntown in 2014. So I am a little bit confused here. The report was made by Connecticut, by DPH in 2022 with the statement that there is a violation, and Connecticut Water is saying that the violation was corrected in 2014. Who is right?
We are right. Yes, it was a significant deficiency and actually led to an E. coli situation in the SDC system. That we worked with the town to relocate that cross drain that was previously draining right towards the wellhead to move it further down the line and to divert that storm runoff to further away from the sanitary radius of that well. That was in that 2014 area.
Right, so the violation is not there anymore.
Correct.
Okay, thank you. On page 140, there is Ponemak Village System Sanitary Report.
okay.
And it is regarding the atmospheric storage tank inspection. And it was scheduled to be complete in 2022. And I could not see the response from Connecticut Water saying that the storage tank was inspected.
I think I would suggest that as long as, along with the other tank inspections, that we just do a confirmation for you as a read-in.
Right? So this is Ponemah is spelled Ponemah, village system. Storage tank inspection in 2022.
Chairman Gillette, just so that I'm clear, are we including that in read-in B, which was the storage tank inspection information for Westchester Village? Or do you want that separate?
I just wrote it down as read in D,
Okay.
just to keep that straight. Thank you.
Page 165, please, of Exhibit 2, RRU 73. That's regarding Guilford system.
Okay.
And the report states that the well is located within the protective radial distance from the filter backwash discharge. Guilford well. So was this corrected? The backwash discharge?
So Guilford Well had a project completed this past year that relocated the well itself. That new well location was still within 200 feet of the existing lagoons. We have a design completed and into DPH for approval to relocate those lagoons as a 2024 project outside that radius, which would fully address that issue.
Okay, now I don't see in the application a response to this survey report. So would you please submit the response that Connecticut Water sent to the DPH regarding this sanitary survey report dated March 28, 2023? March 28. 2023.
Thank you. Okay, so that sounds more appropriate for late file, so I'll mark that late file exhibit 2. Any clarifying questions from the company? Okay, thank you.
So this would be Connecticut Water response to shoreline region, Guilford system, DPH sanitary survey report dated March 28, 2023.
23.
No.
Oh, sorry. All set.
Response to interrogatory RRU 74, please. My question is regarding Chester Village West System, uranium treatment. Is this treatment complete?
Yes, the treatment was completed and installed in the fourth quarter of 2022.
Is the cost of this treatment included in this application?
I believe it is, yes.
Would you point me to the project that was completed? I believe you submitted updated project list. It was like a few thousands of projects. Would you be able to give the project name? It doesn't have to be done now, but maybe another written.
It might be more appropriate as a late file exhibit.
Yeah, that's fine. I think we can possibly find it, but to be safe.
Okay, so we'll mark that late file exhibit 3. Ms. Jewell, I will need that restated, please.
Chester Village West uranium treatment.
Invoice or plan? I'm sorry, what are we looking for?
For cost of the treatment.
Thank you.
A response to interrogatory 75. In this response, Connecticut Water submitted number of complaints that your customers complained regarding dirt, color, stain, taste, odor. How long usually it takes company to resolve those complaints? And what is company doing? For example, with color or dirt, how are you resolving those issues?
Sure. If you would give me just a minute to review.
You know, any complaints that come in to the Office for Taste, Odor, or any secondary standard, we dispatch resources right away. And we stay with the issue until fixed. So if there's a dirty water complaint or a taste and odor complaint, that's not something that we leave for doubt. You know, we get right on that, primarily to eradicate the issue, but also to ensure that it's not a precursor to something more serious.
And do you follow up with your customers regarding those complaints? And if they satisfied with the resolution you offer them?
We will follow up with our customers within 48 hours, so to ensure that we have the laboratory results to evidence what the water condition is.
How do you follow up? You just call them, or you go knock the door, or something else, send them emails, something else?
It depends on the complaint. Sometimes we'll go out there. Sometimes we'll follow up with a phone call.
And usually, what is the response?
Do you mean what is their response? What is
Are
our
customers satisfied? Are they still angry that they get the?
We generally work on the issue until our customers are satisfied. We want to make sure that the issue is resolved and it's not, that they're not left with the same issue. Actually, we also follow up with a letter.
Okay.
We will not leave any customer hanging with a water quality issue. We want to make sure that we drive towards resolution with each of our customer interactions. And in fact, we measure that twice a year within our customer satisfaction surveys and point of contact surveys, so that we will survey those customers to ensure that the answers were provided to their satisfaction.
Okay, thank you. Response to interrogatory RRU 77, please. And this is only housekeeping. The company purchased water and sold some water. What is the unit? As in gallons, 1,000 gallons, million gallons?
They're in 1,000-gallon.
1,000 gallons.
Yes.
Mm. Okay, thank you. Or response to interrogatory RRU 78. So as of right now, the company knows that has 189 lead service lines or replacement. Is this correct?
It's actually 190 as of yesterday.
Yeah, okay, so where else did you find? On customer side or on company side? Let this one extra service line.
That would be on the customer side.
Okay. Now, in docket number 190402, application of San Jose Water Group and Connecticut Water Service Incorporation for approval of change of control, on page 21 of the decision, Connecticut Water proposed a lead service line replacement pilot program to replace 30 customer site lead service lines. And also Connecticut Water stated that will not seek cost recovery for this 30 customer lead service line replacement. What is the status of this 30 service line replacement, taking into consideration that you have 155 customers now with lead service lines?
Lead service pilot program. The lead service pilot program was initiated last year, and we had reached out to a total of 81 customers to make them aware that we believed that their service line may be constructed of lead. We sent letters to the customers. We followed up with phone calls. So we had a significant outreach effort to the customers. As part of the pilot program, we offered to split the cost of the replacement of the lead service lines. It was very challenging in being able to convince the customers that it was in their best interest and, that we were there to help. Ultimately, we only received a total of 6 customers who agreed to have their lead service line replaced. So that we've continued that program with a little bit longer than we had intended because it was very challenging. customers just were not very responsive, and we spent a lot of time and effort to make sure that we educated them and could convince them that this was a good deal, that ultimately we would be need to replace all of the lead service lines throughout the system.
But for the 30 service lines, this should be done with no cost to customers. Why did you offer the customer to split the cost?
That was a condition of the technical meeting when we had it with the commission here on how we would go about conducting this pilot so that the customers would have a stake in the game.
And the meeting was after the decision was issued?
After the decision was issued, how we would conduct the pilot itself.
I believe additionally that the 30 customers was increased to 60 customers. And we reached out to 70, we looked at our system and looked at our 4 regions and tried to spread out that pilot to get a representative sample. And in addition, we had a WICA project that was underway and on a street where we believed that there were lead service lines. So we offered that pilot program to all of those customers on that street, knowing that we were going to be out there constructing and you didn't want to go back in a few years and have them realize that their portion of the line needed to be replaced.
And what was the split cost? What did you offer to customers by percentage?
So 50-50. Our side, if we found the lead service on our side, that was all our cost. On the customer side, it was a 50-50 split.
So, sorry, Jim Bacalina with Authority Staff. In the example that you had there where it was a WICA project and you offered to replace the service line at 50-50 cost, what was the participation there? How many customers would have been on that line and how many people took the offer? How many didn't? Do you know?
I'd like to confirm, I believe it was 2.
Out of 2 that took the offer out of a
Correct.
population of something you want to confirm?
Yes.
Okay. I'm sorry, in that instance.
I believe it was 2 out of 11.
Okay. In that instance, the company, will it replace service lines on the company side if it cannot replace the customer side service line?
Yes, when we find a lead service line, we always replace it on our side. Prior to the pilot, our procedure was to notify customers that they had a lead service on their side and to offer to replace that for them at our cost.
Some previous readings that I've done, there's been concerns about replacing customer or company service lines and customer service lines. Unless you're replacing the entire service line, main to the customer premises. Can you talk a little bit about that and why your approach is you will replace the company side service line without needing to replace the customer service line?
Can you clarify? Are you speaking if there is lead on both sides or lead just on our side?
Or if it's unknown, I guess, on the customer side, but it's lead on your side, will you replace? I guess I was interested in your response that you will replace company only side. Under what conditions will you do that? Only when you know that the customer service line is not lead?
So we will replace our side if we are out constructing. Generally speaking, when we're when we're doing a WICA project, we're replacing our service anyway. From, you know, from the curb to the house, that is owned by the homeowner. So it's not ours to replace, which is why we do the outreach to them and we try to educate them to make sure that they understand that that their service is lead and make that offer to them where we can assist them.
Oftentimes, when we do come across those lead service lines, the outreach is, there's a lot of outreach to them, letting them know what the risks are, what the exposures are, and what the obligations are. And what we will offer to do for them, which is typically to replace their side at what our cost would be. So they get a discount on what their cost would be compared to what it would be if they hired their own contractor to come in to do it. So there haven't been significant amounts of those. But that's been the practice to date, to really educate the public about what the risks really are, which you're referring to as the, you know, that different exchanging one side and not the other.
Okay, just to confirm, what you, in the Wicca project you talked about, you had 11, which you suspected could have been lead service lines. You replaced all 11 and 2 were replaced on the customer side. The other 9 remained with the original customer service line.
I don't believe they were all lead services on that street on the customer side.
Thank you.
Madam Chair, can I ask a quick question while we're on the subject? So for the customer side, so what was the actual cost for them going from curb to home? When it came to, you know, general dollar figure. I know you're not going to be exact on everyone, but
It really varies depending on the service.
how about dollars per foot?
I would say generally speaking, $3,000 to $5,000.
Oh, okay. So that range.
Replace it. There are some anomalies, again, based on
Oh,
the
yeah, yeah.
conditions, but generally
That's a
speaking.
general. Okay, thanks.
A response to interrogatory RRU 79 and then Ailey. In 79, I just want to confirm regarding your meters test. Are your meters on 16-year cycle for testing?
Yes, they are.
Okay, so now let's go to RRU Ailey. And in the response, you said that the accuracy of meter test for year 2023, accuracy of 96 to 102% was 83%. And then you corrected or you updated your response in RRU 460, saying that 89% of meters tested registered accuracy of 96 to 102%. Is this correct?
You would just give me 1 second to review, please. Yes, that is correct.
And this 89% is for what time period?
That would be between August 1st of 2023 and November 30th of 2023.
So altogether, between January and November 30, what would be the accuracy of your meters?
Altogether, it is the 89%.
Do you know the accuracy of meter for December? Do you have these numbers now?
I don't have that now, but can provide that if you would like as a late file.
Okay, so it's provide meter accuracy detail for the month of December 2023.
Yes, thank you.
And if I may just add, during the COVID-19 pandemic, you know, our meters are tested on 16-year cycles, but we did there was a delay in those COVID years that was approved. A delay was requested to PURA and it was approved. So we are through that approval. We're catching up on those meters that were behind, and will be fully caught up by 2028.
That's fine. I just would like to know the meters that you are tested in 2023 for whole year, what is the accuracy of all meters? Because
Understood.
as you know, probably better than I do, that your meters, 90% of meters should test accuracy between 96 to 102% if you want to be on 16-year cycle.
Yes, that is understood.
Ms. Jewell, let me just make sure, based on the exchange that I captured the late file exhibit correct. So do we want the meter testing results month by month for 2023, or we just need them for December?
Average between January and December.
Okay. So provide meter accuracy data, the average for calendar year 2023.
Yes. The one thing I would like to point out is there will be still meters that were due to be replaced in 2023 that will spread out into 2024. So that whole, the entire number of meters that are required to be tested on that 16-year cycle, that will extend out a bit. So
Okay. Understand.
Chairman Gillette, just so that I'm clear, because I think I'm where you were. I think Ms. Schul asked about the 83%, and the witness testified the 83 was attributable to January through August, but the 89% was attributable to the period extending into November. And then Ms. Schul asked about December, and that's when I think you got to, okay, so are you looking for the December number or the calendar year number? And I think she's asking for the calendar year number.
I think so too, but I'm sufficiently confused that I'm going to ask for the calendar year 2023 on average and the month to month for 2023. I appreciate your recap, but it's just for the clarity of the record, revise it to have each month of 2023 and the calendar year 2023 average, please.
Thank you.
Please continue.
Response to interrogatory RRU 81. So the cost of AMI meters is between $75 and $103. What is the cost of regular meters that the company is installing currently in their system? Is it similar, much different?
It's about that cost. Yeah,
Okay.
they are capable of being fitted with an AMI transmitter.
So why the company is not installing more AMI meters? Just installing the regular meters?
We have about 25,000 AMI points installed across our system now, more surgically applied than canvassed across our customer base. We do have a business case that's mentioned in interrogatory responses here that we entered into to test the prudency of an AMI system for us, for the Connecticut Water Company customers. And we're right now considering that for prudent investment for us, and a complete AMI system across all 108,000 customers of ours.
What would be required by the company to do? What would be the cost of the infrastructure if you would install on AMI meters? Would this be very expensive?
It would be very expensive. The business case today suggests a capital expenditure on the order of magnitude of about $23 million. Now, that does include the replacement of about 80,000 meters as part of that project too. But there are as well many transmitters, data collectors, backhaul, IT hardware. It is a significant cost, which is why we went the business case route to ensure that it would meet the prudency test. And we're in the midst of that now.
So if you would like to transfer from regular meters to AMI meters, how long it would take you to do it if you want to be cost efficient?
Typical deployment for an AMI system of this size and magnitude would be about a 3-year deployment.
23 million is a lot of money. So AMI system. 23.
23.
All right, okay, we'll try to be louder. RRU 84, please. And actually you had follow-up in 462, RRU 462. We'll be talking about non-revenue order.
Okay.
There are some systems that 1 year non-revenue order is 0, another year non-revenue order is 62%. And the first system that I seen is Christ Lutheran. It's not big system, but still in 2020 non-revenue order was over 62%. Then in 21 was 13%, and then was 0 in 2022. So everywhere where you have zeros and then the non-revenue order jumps from large number to small one, question is, what is the company doing and why the non-revenue order numbers jump from one place to the other? Is all over the place.
So for Christ Lutheran, for example, what that says to me, when you have a 0 non-revenue and it jumps way up like that, that there's likely a leak. At Christ Lutheran, there was a leaking toilet that caused that, that number to jump up so significantly. And particularly what those small systems, when there's, you know, a small amount of demand there, one leak can cause a significant jump in that percentage.
But you said that was leaking toilet. This would be in the customer's house, correct? Where the toilet was located?
It's the only customer on this system. It's a very small system. And the only meter there is really the well production meter. So and I think it emphasizes the size of system really matters when we are chasing percentages for resource deployment to correct leaking. Certainly in Christ Lutheran Church standpoint, this is one leaking toilet that throws those numbers into a 60% loss category there. And that's noted by you and not insignificant, but I can assure you the toilet was fixed.
Okay. So now we will go to the next one. It's Beechwood. In 2020 was 5%, so this was okay. in 21 was 0, and then in 22 was 18.8%. What was going on here?
I know there was a large leak there. We'll get the specifics on it.
In the meantime, what I will say about Beechwood is that that system has had a WICA project, a phased WICA project that has been underway for the last couple of years. This is a small system that has had a significant number of breaks, and so we have prioritized that as part of our WICA program and have replaced the mains on that.
If you had such a non-revenue water jumping all over the place, aren't you suspicious, don't you suspect that there is a meter issue? And don't you?
No, not necessarily. For small systems in particular, Ms. Gavrilovic mentioned the 25-month production trends that we look at. It can be difficult with these small systems and small wells to certainly acoustically listen for leaks that are small in nature. But when we look at the production numbers, like Christ Lutheran, where a toilet leak can, from a percentage standpoint, can really be indicated and pronounced on a graph. It's through these 25-month looks that we can really pinpoint where we think there is a leak. That's not to say that it would not be the meter. In some cases, it would be. But those meters would be tested accordingly. It's typically leaks. And we can deploy a resource when we have those recognized. An example that I would use is our Legend Hills system in Madison, where there was a leak that started very small and then grew over time. We would not necessarily see it over a 12-month or 6-month look at a production trend, but certainly over a 25-month trend, we can look at the same period of the year against the same period of the previous year and make a distinction there on what our production numbers are. And that's a call to action for us, where we would deploy resources for finding that leak and remedying the situation.
Okay, so 2 more systems I would like to discuss with you. Soundview, Rivercrest. It has non-revenue water 0 and then jumps in 2021 to 36% over and to 22, almost 29%. What is company doing to fix this problem?
Can you repeat the question, please? It was Rivercrest.
The system is Rivercrest, Rivercrest.
So the Rivercrest system is one that we pay particular attention to. It is a supply stressed system that is located in Portland, Connecticut. When we do reveal or detect a leak through analysis that you're looking at there, or through the 25-month analysis, we need to deploy right away because we just don't have the supply there. One of the things that we're doing there in particular is we have located a supply well out there that will certainly take care of the supply deficiencies that are evident in Rivercrest and have been forever. So we feel like we've got a good answer there through a lot of hard work by the team to locate a well out there to solve the perpetual issue of Rivercrest. But it's so it's also an older system and one slated for a WICA replacement as well, because it is prone to leaks.
Yeah, 1/3 of your water goes in the ground. In the system, Rivercrest, 36% or close to 30%.
That's, and that's not water that can be afforded to do that, which is why we need to jump right on those numbers when we get them and put resources towards the fix, because we just don't have the supply in that area. And it's not unusual for the entirety of the Route 66 corridor.
And the last system I would like to ask you about is Stagecoach. And again, in 2020-21 was 0%, and then suddenly in 22 is 41.1%. Is this meter issue or is this other issue? You really have a leak.
So it looks like Stagecoach in 2022 had known uses or losses of 0.31 million gallons. So the unaccounted for water is zero. And that known loss was a customer side service leak that was identified and repaired.
Thank you. Response to interrogatory RRU 97, please. And this is again housekeeping. The first table shows volume of water purchased by Connecticut. What is the unit? Gallons, thousands, or any other unit?
It's in thousands of gallons. So for example, that MDC number would be 443 million.
Thank you. RRU 111, please. Connecticut Water submitted application to DPH regarding wells abandonments. When did you submit this application to DPH? And did you get approval or not yet from DPH?
I believe we'll have to verify that and could provide that as a read-in.
Wells abandonment. Turner Road, wells 1 and 2. Amston Lake System, wells 1, 2, and 3.
Actually, I apologize. I can respond to that now. We have submitted them over the course of the last several years for all of those wells, and we have not received any approvals yet.
Okay, thank you. Response to RRU 112, please. So the last statement or last paragraph says that wells at the Beechwood system in Killingworth have detection of PFAS, above limit and are being treated with existing ion exchange units, which was installed for removal of uranium. How successful you are in removal of PFAS with this system?
Could you repeat that, please? I mean, just the last part, how?
How successful you are in removal of uranium?
We, as part of our voluntary testing that we worked with the Department of Health on to determine which of our sources had detections of PFAS compounds, Beechwood was one that stood out and continues to stand out. Our raw water numbers there are on the order of magnitude of about 140 to 200 parts per trillion. But our finished water is non-detect. We had installed uranium treatment systems in there, which are ion exchange units, in 2008 for the purpose of removal of uranium. Lo and behold, it was pretty effective at removing PFAS as well, and had been doing so. So we continued to test, added another train of vessels, ion exchange vessels, as another barrier for that PFAS removal. But it's very successful. It's removing to non-detect levels and has been for some period of time.
Okay, thank you. Has Connecticut Water submitted an application to DPH for another program like state, not only state revolving fund, drinking water state revolving fund, but is there any other program that Connecticut Water can submit application and seek post-recovery or help with loans through Connecticut or through the federal programs?
For PFAS removal specifically?
For PFAS or for any other contaminants that Connecticut Water finds in their system? Are there, and I'm sorry, are there any other programs that you can submit application?
I'm not aware of anything else in Connecticut that we would be able to submit for, but I do know there is the WIFIA program. That's a federal program, but that is, I wouldn't be able to quote all of the details, but I know that that is for significantly large projects. So I don't believe that there are any specific grants or subsidies for these types of emerging contaminants. And those are, to the best of my knowledge, those are strictly loan.
So my point is, are you looking for any subsidies, any grants that you can get from federal or state?
We are always looking and always, paying attention to what is, changing requirements, additional funding that becomes available. We are also part of the Connecticut Water Works Association, which closely follows new regulations, new funding opportunities that are could be evolving. I'm just not aware of anything at this time.
Thank you. That's all my questions.
Thank you, Mr. Vocalina.
Okay, thank you. I have some questions regarding the lead service line replacement program. And I know Ms. Jewell has asked some questions, so I'll try not to repeat. Just starting out, the lead service line replacement program is in direct response to the revisions to the lead and copper rule, correct?
Correct.
And those revisions take place in October 24, you mentioned, I believe?
That is the first deadline, and that is for the inventory submittal.
Okay, I mean, lead to my next question. Can you explain the additional requirements of the company as of 10/24, October 24. What happens at that point?
At that point, we also will provide a schedule for identification of those unknowns, as well as a schedule for replacement of the lead service lines that we have identified.
No. In your pre-file testimony.
Oh, can I just add something to that? I apologize. Additionally, the action level, which is currently set at 15 micrograms, it will set the action level at 15 micrograms per liter, and the trigger levels at 10 micrograms per liter.
In your pre-file testimony on page 12, you mentioned that the company was nearly completed with the initial service line material inventory. Has that been completed?
I guess what I would say to that is it won't be completed until we know all of the unknowns. In order to submit to DPH, it is, as I had mentioned previously, what you know and what you don't know. We're continuing to work to identify those unknowns.
Okay. Yeah, I guess my question, when I read initial, do you have for the company service territory, these categorized into non-lead, lead, and unknown? at
We
this
do.
point?
Yes, we do.
Okay. Can we have those numbers in a late file exhibit, please? And how those categories, the numbers that have been revealed so far?
Sure. Would you like that broken down by each service line material or just lead, non-lead, and unknown?
Yeah, if you could provide that by the material, that'd be.
Sure.
So that's late file exhibit number 5. So provide a breakdown of service line material. Maybe if I could add a friendly addendum and ask that you, if there's a way to clarify what percentage of the population of lines like that represents, because it sounds like you haven't completed the survey, but it'd be good to know what that represents. If that makes sense. Thank you.
Okay, and as you mentioned, I believe the next phase of the project is to identify what the unknowns are.
Correct.
And replace those that are known to be lead service lines.
Correct.
Concerning the identification of the unknown, those will require investigations or field visits. Is that how that you'll determine the unknowns?
There's multiple ways for verifications. It's a little complicated in the rules. So we will be utilizing all aspects of those approved methods. It includes customer survey that we have formulated and will send out to customers, hoping that they will be able to identify those lines with some guidance on that and forward photos to us so we have documentation of that. We also, during our meter replacements, when our field service staff are touching our customers, we're utilizing all of those opportunities to further identify our service material. And also through our WICA program, when our contractors are out there and we're overseeing the construction, we're utilizing every opportunity we can in this period of time to decrease the number of unknowns.
Okay. To the extent that you're not able to use any of those others, though, and field visits are required.
Yes, that is correct.
That's sort of the last.
That is correct, yes.
Has the company been able to estimate the number of field visits that it would be able to accomplish in any particular year?
We have started looking at, based on the numbers that we know currently, we've started looking at a timeline for that identification and replacement of those lead service lines. We've also, Another consideration for us in order to gain efficiencies, we're looking at, should we move forward with an AMI project in the next few years? We want to, you know, if we're going out there replacing customers' meters, that's a perfect opportunity for us to identify the service material. So we're looking at all of those as we develop our plan for identifying the unknowns and moving forward with the project following that October 2024 date.
Okay. Would it be fair to say that the field visits are going to be the most costly?
Yes.
Out of the alternatives that you have for identifying the unknowns?
Yes.
Okay.
Yes. So we will look to identify every other way first. The difficult part is that we don't have meter pits for many of our services, so it may require digging.
Okay. The other primary cost here is the replacement of those to be found to be lead service lines. And has the company estimated their ability on a resource basis to, how many lead service lines could you hope to replace in a particular year?
So as I mentioned previously, we have applied for and plan to move forward with DWSRF funding for this initiative. As part of that, there needs to be an open and competitive bid. So we are not allowed to utilize our own resources to do that work in order to remain eligible for the funding.
Okay. Now, just to be clear, the costs that the company is seeking to defer, are those related only to customer service lines? Customer side, the company side will go into a regular capital account.
Correct.
And the projection is $45 million in cost for both the company and the customer side. What I would like is, to the best of your ability, when we went through 220701, which was the Aquarian rate case, and we reviewed the lead service line replacement program, the company was able to give us an estimation of what could feasibly be accomplished over the first 5 years of the program. So I'd like something similar from the company in that, for what we talked about with the identification of the unknowns, the replacement of service lines, and then any other costs that are being required of the company that you're looking to defer. I guess I should start there. Are there other costs in that deferral besides the investigations or other methods of determining unknowns and the actual lead service line replacement? Is there anything else included in that $45 million?
No, there is not.
Okay. Okay, so it would be those two items, what we can expect over per year on an annual basis over the next 5 years.
Including,
In terms of dollars
Yes,
cost.
number and your cost estimation for.
Sure.
okay. So I have that as late file exhibit 6, inclusive of any assumptions and the breakdown of costs. Correct. Okay, very good. Any clarifying questions or?
No.
So you mentioned the DWSRF application has been filed, but no expected determination at this point of when you can expect an answer back on whether you've been approved for this or not.
The project is eligible for funding.
Okay. And I know there was some talk about higher priority projects, maybe, I don't know, mischaracterize that versus lead service line program, but that there would be funds available on a subsidy and a low interest sort of split with, for lead service line replacement program.
Yes, I believe the lead service line program is included in the category called emerging contaminants. So there is a higher subsidy associated with these projects.
And the subsidy is to the company itself, or is it on the customer side? How does that work? File an application for the customers within your service territory,
The subsidy would be for the project
Okay.
itself.
which would include the customer side if they chose to enter into the program. I guess, which we've talked about would be 50-50 split in cost. Would that be eligible for the subsidy on the customer side?
That was part of the pilot program that we completed. I don't know that we would be able to continue that moving forward. I think there's still some clarification in the rules as to the responsibility of those customer side services. Currently, the customers are responsible for their side, but there are many intricacies, as you could imagine, in forcing a customer to replace their service line. So we're waiting for further guidance on that.
Okay. So for the subsidy there, the expectation would be that goes towards the company's side of, for the, well, you mentioned project, and I guess I didn't quite understand the answer there. Any subsidy that came from the DWSRF would go to offset the costs on the company side.
Yes, which would ultimately benefit our customers.
Okay, just going back to the merger commitment, and I know it was initially 30 customers, lead service line replacement. It looks like, that was changed to a 50% contribution, and therefore the number of customers up to 60. Is it the company's thought that going forward, they will still fund those 50% of those 60 customers, minus the 6 that have been replaced in the pilot program? So I guess we're talking about 54.
Well, it's, there was not an interest there from those customers. I think the purpose of the pilot was to help inform how we collectively wanted to think about the funding of these customer side services. Should the customers participate in it as the owner of that? Should the company pay, meaning the bulk of all of the customers? So I think, prior to us being able to commit one way or another on this, we need to work with the commission to really establish a way forward, which is why we're proposing the deferral of costs now, so that we can meet the compliance thresholds that are before us. But we'll need to work with you all through a technical session or a docketed proceeding so we can examine just how to fund these customer side services.
But to the extent that there was a dollar value placed on those, I'll call it a shareholder contribution of those 30 that were the initial. It's a $5,000 per service line. That's $150,000, and the company has replaced 6 of them, which would be much less than that. Is the company of the position that those funds are still there to provide for subsequent replacements on the customer side?
Oh, you mean as an offset?
Yeah.
On the go forward. It was the spirit of that was really for the purposes of the pilot itself to garnish the information that we would need to make a better informed decision for the totality of the replacements.
Okay. Okay, thank you.
Okay, Attorney Riley, please. Or Attorney.
Can you hear me okay?
Oh, so far.
Okay, thank you. Good morning, everyone. Jim Riley, staff attorney with the authority. I just wanted to briefly touch on, it was testimony from you, Mr. Patla. We were discussing the lead service replacement program pilot, and more specifically, the agreement or the decision and settlement and agreement in docket 190402. Where I believe there was a commitment in that settlement agreement for 100%, or where the company was not seeking cost recovery for, I believe it was 30 customers. You mentioned subsequently there was a technical meeting where it was discussed that there might be this 50-50 split, I believe with 60 customers. Just what I'm trying to understand is, do you know like what docket or what proceeding you're talking about? Or I know it's difficult to pinpoint a docket number on the fly, but do you have any additional context about what that proceeding was regarding?
Yeah, if I can jump in. So there is a compliance filing in the 190402 docket. It was on February 5th of 2020. And attached to that compliance, there's an outline of essentially the agreement that has been referred to today.
Okay, so to your knowledge, subsequent to this discussion and this compliance filing, was there any subsequent authority order or decision approving or providing any sort of guidance regarding that plan?
I believe it was memorializing what occurred at the technical session, and that was the purpose of the compliance filing. So I don't think there is any, specific approval of the compliance.
Okay, and to the best of your knowledge, was there ever an amendment that was executed to the settlement agreement approved by the authority in 1904-02?
No.
No. One moment, please. And just to confirm, so at this point, has the pilot program ended?
Technically, yes, but due to the low response rate, if someone calls in, even though it's past the time frame, we are extending that offer to them.
Thank you. I was just confirming with my co-counsel. To the best of the company's knowledge, did the settlement agreement indicate a length of time or a date in which that program would, the pilot program would terminate?
It did. I don't have that exact date here, but I do know that request was made to extend that based on the COVID-19 pandemic.
Okay, and that was a request from the company?
Yes, I believe so.
Okay, and to the best of your knowledge, was there any subsequent like order approving that from the authority?
I don't recall.
Thank you again. So was the settlement agreement then ever subsequently amended? I'm sorry, so was that ever amended? So that settlement agreement, was that ever amended and agreed to by all of the signatories from the previous settlement discussion or agreement?
I believe so. If you'd give us just a minute, we might be able to pull that up.
Thank you.
Please.
If I may, it might be helpful if we could designate the subject matter as a late file exhibit, and we'll go back and try to document the history of the settlement agreement and the issues that have been discussed this morning.
Okay, I think we can designate it as late file exhibit 7, but I think what we're specifically looking for is an authority order or something that was submitted to the authority by the signatory parties in which there was an authority decision to modify the settlement agreement. So, I mean, we can forego the history. I think we're just looking for a copy of whatever document the authority and or the signatories have issued that amended the settlement agreement. Okay,
Understood.
thank you.
Yeah, and then two more questions. So who internally is responsible for pursuing non-ratepayer funding? And how do they make the decision to forego applications for federal funding?
I apologize. Can you repeat that question, please?
Sure. So who within the company is responsible for pursuing non-ratepayer funding for these service line projects? And how do they make decisions to forego applications for federal funding?
Are you referring to the DWSRF applications that we're submitting?
Yes, and more broadly, the just the lead service line replacement as a whole.
Well, we've applied for everything we feel we are eligible for. I don't believe there's a foregoing at all. So that I'm certainly aware of.
Correct. Well, what we've submitted thus far is for the lead service line identification and replacement. So yes, we have covered everything aside from the work to identify the materials and the work that we've done to date for that inventory.
So I think just to clarify one more part of my question. So who internally is responsible for pursuing any federal funding opportunities generally within the company?
I would say that I am.
And so what documentation or any other additional internal protocols exist for pursuing non-ratepayer funds?
We don't have any written protocols per se. You know, when money becomes available, as when the call for projects, for example, for the SRF program comes out each summer time frame, we will identify which projects we feel will meet eligibility, and we will submit applications for said projects. In this particular case, where we are with the lead service program, we feel like we were eligible there for inclusion, and we're able to confirm that. And so we would submit the application and execute.
So previously it sounded like some of the testimony I heard indicated that the company needed clarification in the rules relating to customer service line replacements. So what sort of clarifications are the company seeking?
I think it's really just clarification through the new rules coming out, just considering, the logistics behind either saying that the customers are responsible for their side, when there's a 10-year timeframe to comply with those regulations, how do you ensure the customers are replacing their service line in addition to utilities replacing their service line? So I think that those are issues that are still being considered by the federal government and will subsequently, but with the state government. So we're just, as we're going through and working through identifying whatever we can right now to lessen the burden as we go down the road. I think we're just, keeping in tune with any future guidance on that.
And then are there any other, anything other than the pilot program ongoing with the company's efforts to replace customer lead service lines?
There is nothing additional on the pilot.
No further questions, Chairman. Thank you.
Thank you. This is a good time for our lunch break. So we will take a lunch break until 12:45. When we reconvene, it will be with Cross from the Office of Consumer Counsel. Please. Thank you.
There's not. That's two. We'll steal mine for a while, Brent. No. Yeah. See if you can get them.
Okay.
I bet it's him. Yeah, so we'll want to work with David. And we'll just do the readings. Likely when we reconvene.
Everybody's like, okay.
So
I'll keep
maybe I'll
looking at
just
break.
come over.
I'm gonna take my computer with me anyway, Brian, so. So I'll plug it in when I come back.
Yeah, I would make sure those guys are working. Most of those things we should know.
I think we've already got them in there.
Should know that stuff.
Yeah.
Sounds like there's a delay in like sending questions and us getting them. So we just need them. We don't need long sentences of explanation, one word things. I would make that. Thank you.
Okay, I'm all right. Teresa, you know what you're going. A lot going on. The rate cases are bad enough, never mind all the other crap.
All right, good afternoon. Any administrative matters? Attorney Bogan? B, C, and D. Okay. Very good. Mr. Peeling, if you just want to go in order or,
I think it was Reed and Bravo, Westchester Village tank,
yes.
asking about the date of last inspection. The next, that one has not been inspected, is due for inspection in 2024.
Okay.
Reed and Charlie was the Soundview tank. Last inspected 2018, due for reinspection 2024. Reed and Delta was Panema tank. That one was not inspected in 2023 as planned. We were not able to access for a remote vehicle or take the tank out of service because that's a small system. So we have to have an alternate supply source during that, so that it's now scheduled for 2024. And I'll make the point, all of these were part of the sanitary system reports, which generally are pointing out maintaining our routine frequency of tank inspections, all of these which fall within the regular inspection interval.
Thank you. Okay,
Chairman Gillette, I have a couple additional read-ins, if that's okay.
of course, if you could just identify, please.
Believe it was the first one, Avon Well 5.
Yes.
Per the town records, 111 Craigmore Circle, which is nearest Avon Well number 5, is now tied into the sanitary sewer system as it was proposed to be.
Okay, so the distance from the septic system is NA.
Correct.
Okay, thank you.
Additionally, the Soundview, the well cap on well number 11. And I apologize, I don't have the letter for that one.
I don't have any more letters. So if you think it was outstanding.
Soundview well number 11.
Okay.
There was also a well cap.
There was also a well cup.
Okay, very good. Add it to read and see. Charlie, please.
So additionally to see the Soundview, the cap on well number 11 that was cracked has now been replaced.
Thank you. Okay, so I think we're all caught up.
I have one.
One more.
further.
Please.
I don't know the letter, but there was a question about the Chester Village uranium system and where to track that in our capital plan. The reference for that project is RRU 283, Exhibit 3. There's a tab for 2023, 1 through 9. Line 80 of that reflects in-year service delivery identified small capital projects for water treatment plant equipment at $183,000. 92,859 of that was for the uranium treatment at Chester Village.
Very good. I think that was actually a response to late file exhibit 3. Do you mind just submitting that in writing so I don't get out of order here? But I appreciate the response. Thank you very much. So we are all caught up with read-ins. Any further administrative matters before we turn it over to OCC? Very good. Okay, then Attorney Wheel, whomever would like to kick us off from the OCC, please.
Commissioner Karen, Richard Sobolewski for the Office of Consumer Counsel. If we could start with OCC 147. This discusses the underground asset management prioritization tool and the vertical asset management prioritization tool. How have these changed your capital planning?
We like to think both these tools supplement and improve our capital planning by giving us a new way to evaluate project need and project prioritization. Both of these tools quantify risk to our customers, risk of interruption to delivery, water quality risk, environmental risk, and puts a rating to that allows us to score not only among similar assets, but across different asset types. So when we select prioritization for projects, we are truly getting the best risk reduction per dollar for the customer that we can in the projects we select, and take a little bit of the subjectiveness out of project selection.
Okay, so it's a scoring system.
Correct.
Okay, and that carries over into your budget process on, what you set for given years and what, I'm sure, the board still sets, whatever the total is, but these tools impact that as well?
Right now, the tools are focused on the prioritization within the budget allocation. They're new tools, so we're going to hopefully see that process mature a little bit, where if we see different investment amounts may achieve some significant increase in risk reduction, we might be able to show the benefits of that and advocate for it.
We could go to OCC 158. The contingency factors, those are built into your capital budget and built into the forecasted level of plant and service at the midpoint of the rate year, is that correct?
So for OCC 158, we are speaking to the contingency factors applied to the specific projects in the 2024 capital plan. It really varies by the project type, since some of these are farther along in their development. Some of them have completed designs that allow a pretty well-defined project scope that makes a lower contingency factor appropriate. Some of them remain very conceptual and undefined, which warrants a higher contingency factor. So it's not universally applied across the capital program. It's really applied project by project.
But the level of capital expenditures that you have in rate base forecasted going forward, theoretically, they include the contingency factors.
Correct, they do.
I don't know if this is the right time, but I'll ask the question anyway. OCC 165. Deviations from prior precedent. One item in regards to rate base, the company has projected to the midpoint of the rate year capital expenditures, is that correct?
Plant additions, yes.
And that's something that the company has not historically been allowed, is that fair?
Has not been allowed, but it's traditionally what we ask for to line up with the effective date of rates.
In regards to non-revenue water, I know there was some cross this morning from your staff. I know that there's an exhibit, one of the Pure RRU responses. It shows the non-revenue water for the systems that missed the 15% in the test year. Is that? It's
RRU 101 possibly?
okay, thank you. And I know there's an exhibit that also shows what if Pure made an adjustment based on test year for those systems that missed, there were amounts delineated there for above the 15%. Is that correct?
Yes, that is. RRU 84, I believe.
Right, thank you. In regards to non-revenue water, your total was below 15%. Have you seen significant improvement over the years with non-revenue water?
We have, when we made the commitment as part of the mergers, I believe from a company standpoint, we were about 18%. And now we sit below 14, around at 14. That represents a significant amount of water found, on the order of magnitude of millions of gallons.
In regards to lead service line replacement, I know there was quite a bit of discussion about the pilot and, you know, what's happening going forward. The company's not opposed to having a generic docket to discuss, you know.
We are
We're all
not.
headed on that.
We are not.
In regard to PFAS, I think this morning it was stated there's 43 different systems, and I don't know if those are the ones that have tested above the 4% potential standard or proposed standard.
Yeah, our data set through today shows 80 groundwater sources in 43 different systems, higher than the proposed threshold of 4 parts per trillion.
Has the company done any assessment on what the potential cost for treatment is at the 4%?
We did a preliminary estimate in May of 2023 when the data set was a little smaller than what it is today. We currently have a master plan project in progress that's defining a little more specifically what method of treatment would be appropriate for each of these sites, establish the size, get a better feel if we're talking about new buildings or equipment in existing buildings, and better project out what the investment is going to be required under different timelines for compliance.
In regards to PFAS, once a standard is known and requirements are set for compliance, do you think that's another area that a generic docket from Puro could be beneficial?
I would say
Yeah.
potentially, yes.
There's considerable investment that would be required, so that seems like it would be appropriate.
In regard to PFAS, I know Mr. Palla was here quite a long time. Maybe he was here when we used to do the QUIP surcharge cases. So is if there was a statute passed to do something similar to that for PFAS, you think that would be helpful? That would allow you to.
So you're referring to when we use QUIP on with the advent of the surface water treatment
Right.
rule, where all the builds of the surface water treatment plants happened in the 80s. And yes, something of that nature would certainly be beneficial.
In regards to that earlier, Mr. Peeling, the earlier 43 systems, can you share with us the number, what the cost was?
Our preliminary estimate was in the range of 80 to 120 million.
In regards to, we can turn to, I think it's RU 74. There are a list of projects or systems where either you had consent orders or you were failing to meet certain water quality standards. Or you had a notice of violation. I know there's some cross about Chester Village this morning. With the uranium treatment, that system's all set now, is that correct?
That is correct, and we're receiving non-detects at the point of entry.
For Jensen's, there was an E. coli issue. So it sounds like you increased chlorine treatment there.
No, that was actually a lab or a sampling error where we received the initial E. coli sample result. This one, actually, I apologize. Can I just have 1 minute? I just want to make sure that I'm referring to the correct one. Okay, so that is correct. Repeat samples, the requirement of the total coliform rule is if there is a, even a total coliform positive result, it still triggers the E. coli MCL. So what we did there is we initially issued a precautionary boil water note advisory for that system. We chlorinated the system and took repeat samples, which came back fine. Additionally, we were required to do a level 2 assessment to ensure that everything, that there were no issues out there and everything was returned to normal service.
The chlorine treatment was temporary. That's not something that's going to continue.
That is correct.
When do you decide that a permanent solution is needed?
So we do have a few small systems that are unchlorinated, and we have over the years had projects that address those small systems. We do have project coming up looking at these small systems and looking at where we can institute the chlorination. I believe we have a project for 2024, but let me verify that for small system chlorination. I
Yeah,
believe
there
they're
is
doing.
an ongoing program for small system chlorination projects, working through the remaining systems that don't currently chlorinate. And at the end of that program, over a few additional years, that all systems will be fully chlorinated. I don't know where Beechwood sits in that queue right now.
And these are smaller systems that most of them that you took over from someone else.
Correct.
Beechwood system is scheduled for 2024.
For Miami Beach. I know you've been making improvements there since you took it over, and there's more schedule going forward. Is that correct?
That is correct.
Okay, is Miami Beach the only system that you currently have that has a surcharge?
Yes,
So there's no old system from prior to the last rate case that have surcharges?
no,
Okay. In regards to Miami Beach, the surcharge, is it based on all the improvements that have to be made to Miami Beach? Or is it based on what you've done so far?
The surcharge was a fixed amount set at the time of the docket, which essentially is accumulating funds towards the final solution that we're going to put into place at Miami Beach. Once that's complete, there's going to be a reconciliation of the dollars collected through the surcharge. Those dollars are going to be used as a contribution in aid of construction against the project costs.
thanks for that, because that's one of the areas we've come across, like with, keeping track of what's going on with surcharges and acquisitions after they happen, so thank you for that. At the hearing in Ellington, November 1st, I think it was, there were several complaints about iron or manganese in the water. Have you looked into those situations that were talked about at that hearing?
Well, looking into, we certainly reviewed our customer complaints.
Mhm.
And the only customer complaints that we had gotten in that area were very few in nature, but on a dead end. Which we, as I stated earlier, we get right on and conduct whatever is required for remediation of the condition. At the Ellington public hearing, it had the appearance of being much more broad. But we don't have any indication of that. And in fact, we don't have a record of that customer in particular calling. So we need our customers to call, and we're very responsive to that. In that particular case, we didn't have any instances of that.
In regards to metering, I know there was a discussion earlier today about AMI and the cost of an AMI system. Is the company proposing an AMI system at this point?
We are not proposing one as part of this docket. We are still considering the content of the business case that we have in hand.
When you decide on if you're going forward, is that something you plan to bring before the authority, or you're just gonna?
With an investment of that size, and as we indicated, being around the area of $23 million, we would seek at least a technical session.
Yes.
Thank you, Chairman Gillette.
Thank you. In regards to AMI, are you aware of what companies are doing AMI for water? What water companies have AMI systems?
I believe that the Regional Water Authority, South Central Connecticut Regional Water Authority had deployed an AMI installation a couple years ago.
And at this point, you have very little AMR or AMI, right? Is that correct?
We have around 25,000 points or customers with primarily walk by, drive by, which is AMR,
Yeah.
and 3 systems which are AMI, which is reading transmitted back to the office.
One of those, UConn?
One of them is UConn.
In regards to the deferred tank painting. Basically, what you're doing is you paint the tank, then you amortize it and recover it over 10 years?
There is some variation, but most of them are 10 years. Yeah.
In regards to what's requested in this case, there were 3 tanks that were in the schedule that were not yet painted. One or clean, maintained, whatever it is. I know one was the western tank, there was pressure washing. Has that been completed?
Yeah, the western tank power washing has been completed.
Okay, how about the Crystal Springs tank?
I'm trying to remember the interrogatory reference. Do you recall what that may be?
RRU 117?
You want this one? This is where we.
And I know it was also in the schedules for WPB 6.0 and WPC 3.10.
Right. The response to RRU 488 updates the pro forma tank painting that we had built into the case. So there's a status in there and we'll reflect that in our final schedules.
Okay.
Those tanks instead.
There was also Snip 6th Street tank. That's the third one I have.
Correct. That's another one that was deferred from the 2023 plan.
Okay. Trucked water, RRU 122. Wondering if you can update this response to include the last 2 months of 2023.
Yes, we can provide that.
Okay, what's requested in the rate case? Is it based on the test year, or is there some average, or do you do a forecast of what the costs are gonna be?
It's going to be the test year that's requested. I think it probably falls under, the inflation adjustment for unadjusted items within the case.
Henry, do we ever got the late file for those final?
So we're up to leaf file exhibit 8. Okay, what was the original, RRU reference again, please?
122, but they were final.
Okay. Yeah.
I have cross on other particular panel projects, but I'll save that for the next panel. Is that? Thank you. That's all I have.
All right, we have some questions from attorney.
Okay, I believe Mr. Peeling, you referenced a PFAS master plan that is currently underway. Is that designed to address PFAS at the proposed levels in the EPA regulations?
The analysis is based on the assumption that the 4 parts per trillion will be the standard.
Okay. And to what extent has the PFAS master plan been completed? Where are we?
It's underway. We're about a month or two into it. It's scheduled for completion prior to mid-2024.
Has the company received any customer complaints about PFAS?
I'm not aware of specific complaints.
I'm not aware of any specific complaints. Inquiries. And it should be noted that when we did our voluntary sampling program throughout our systems, where we did have indications of presence, we did notify all of the customers being served water by those sources as well. So that, I'm guessing, would have prompted some calls. The nod indicates yes from the back.
Thank you. And when you say you notified customers when the level was above a certain limit, is that referencing the proposed EPA level of 4 parts per trillion or the higher level that was set by, I believe it's DPH?
It wasn't proposing any of that. It was just that there was PFAS detected within the water that was that is provided to them, and then gave information provided by the EPA on the considerations for PFAS in water.
Okay, thank
We
you.
didn't have the limits established when we conducted that testing, either action levels or proposed maximum contaminant levels.
Okay, thank you. What technologies does the company currently use to remove PFAS from drinking water?
The only removal that we're doing right now is at the Beechwood system, as previously referenced in Killingworth, and that is an ion exchange units that were previously installed for removal of uranium, but is quite effective at removing PFAS as well, or the PFAS compound present there, which is PFOS.
Okay. I believe, forgive me, I don't have the interrogatory, but there was a reference to granulated activated carbon filters that were present at other sites. Is that, do those remove PFAS, or those aren't currently used in that way?
Granular activated carbon is an accepted method for PFAS removal. Any granular activated carbon that we are removing, that we are using for, would be for another purpose, typically taste and odor removal, that would consequently as well be removing PFAS if present.
Okay, so just for my clarification, you're saying that there might be removal of PFAS, but the only specific technology that you're using to remove PFAS, not sort of incidentally, but intentionally, is the ion exchange.
That's correct.
Okay, thank you. Earlier, there was testimony that you had not heard from customers in the area regarding manganese in their water. So were you not able to follow up on the comments from the hearing, as you didn't have a record of the customer complaint?
We followed up with each of the customers that presented that issue at the Ellington hearing. And no further we followed up with them, but no further concerns.
Okay. Was there any sort of general review conducted by the company to determine whether there was a manganese or general discoloration issue sort of in the larger area?
Specific operational review, we didn't, other than our regular annual maintenance of the system, which would include flushing and an indication of elevated or out of normal appearance for any iron or manganese appearance.
Okay. Thank you. Those are all the questions I have. I'm going to turn it over to my colleague, Attorney Tom Wheel.
Thank you. Mr. Patla, page 7 of your testimony references a formal delegation of authority that lays out responsibilities between the subsidiary and the parent. Is that formal delegation of authority in the record?
I believe it is.
I saw the response to RRU 487, which lays out approval limits for purchase and change orders. That's referenced as a delegation of authority, but I wasn't able to find something that lays out the responsibilities as referenced in your testimony. Do you know where in the record that would be?
Would you reference the interrogatory again, please?
Yeah, RRU 487. There's also a RRU 169 Exhibit 3 referenced by RRU 487, but again, those are the purchase limit the purchase authorization limits.
So Attorney Wheel, would you be looking for the specific delegation of authority document as part of the merger?
Yeah, I'm just looking for what you reference in your testimony. It's on page 7 towards line 112. You say a formal delegation of authority details the roles and responsibilities of the Connecticut management team and specifies the extensive authority vested in the boards of the Connecticut Water, the CTWS and CWS from SJWG to assure local control. Is that a document that's part of the merger?
I believe it is, subject to check.
Okay.
This delegation of authority referenced in RRU 487 is more delegation of authority within the CWC organization for things like authority on spend and sign off.
Right.
It is not a delegation of authority from the parent company to the subsidiary.
Yeah, that's why I was asking about it, because I was just searching the record for anything that looked like a delegation of authority. That's all I could find. So that was the nature of my question was, that's not, I guess, it sounds like what you're saying is that's not what you're referencing in this testimony, that delegation of authority.
That is not the delegation of authority referenced.
Okay. And the delegation of authority that's referenced, is that filed in this proceeding anywhere?
I don't believe it is.
Okay. I have some questions about environmental stewardship and the corporate responsibility committee that you also talk about in your testimony. There, you reference bird nesting boxes, a pollinator garden, a discount rain barrel purchase program, and I think you refer to all those as volunteer driven. So are all the costs of those programs donated by the company?
Yes, I believe they are.
Okay. Do you know how the funding for the rain barrel purchase program works? Or just, actually, I'll back up. How does the rain barrel purchase program work?
I'm going to suggest that we table this question until Michelle Williams is sworn in during her portion of the proceeding. She heads up our corporate responsibility committee and all these activities that are associated with it.
Sure. Okay. So would she, I had some questions about the sustainability report. Would those also be better directed to that panel?
They would.
Okay, sure. Your testimony, and I should start out by saying I acknowledge your testimony is sort of an overview. So if there are better panels to address these questions, let me know. On page 12, there's a reference to over 1,000 acres that are permanently protected. I was just curious about how the company defines that. What's a permanently protected acre?
Could you give me a line reference?
Sure. On page 12. That sounds right to me. I'm not there yet. Yes. Yeah, line 246. It says sale of donation or donation of land to conserve open space, permanently protecting over 1,000 acres.
Yeah, it's the reference to that is open space with permanent easements placed upon those parcels of property, designating them as conservation easements.
Okay. I had some similar question around the same area of the testimony. There's a reference to a memorandum of understanding with Save the Sound. Is that MOU in the record in this proceeding anywhere?
I believe it's in a previous proceeding. I'm not certain which previous proceeding. I don't believe it's part of this proceeding as far as material being provided.
Okay. Your testimony references a report filed in 2021 in docket 190402. There's a reference to 6 additional land sale agreements. I just wanted, I think that might be a typo, so just the date on the testimony, just checking, because I looked in that docket and I found a report that sounds very much like that was filed in October 30th, 2020. Is it possible that's the report that you're referencing there?
Very likely is.
Okay, just for clarification, referring to maybe as a read-in, you could just confirm. I'm referring to a filing on October 30th, 2020 in docket 190402. So just looking for confirmation that that's the report, and if not, my question is just where is that report? Because I wasn't able to find a 2021 report filed in that docket.
So a read-in.
Sure.
Yes, please read in E.
Thank you. I was curious, when there are these land sales subject to the Save the Sound MOU, as I understand it, it's promoting sales of lands not located in watershed to municipalities or environmental conservation nonprofits. Is there any revenue impact? I assume there would be. Is there a reduction to real estate taxes that are incurred by the company as a result of those land sales?
Usually with each land sale, there will be a net proceeds or some sort of net gain, which the decision in each of those cases sort of decides the sharing of that gain between customers and shareholders. There's also usually a reduction in some property taxes, but given that the parcels are usually on the books for such little value, it's a pretty small value in terms of property taxes.
Okay. And each of those transactions is approved by the authority in a proceeding?
Yes, I think there's certain criteria of, I think it's $50,000 that it has to be the sale value for it to require pure approval.
Okay. Thank you. Mr. Pala, on page 15 of your testimony, there's a mention of that despite a test year inflation of 13.5%, the company's O&M costs only rose 6%. I was just curious if that kind of productivity ratio has been considered in the proposed inflation adjustment in the revenue requirement proposed in this case?
No. Generally, any of those, I'll call them efficiencies or places where we're able to do better than inflation, those are going to all be reflected in those specific pro forma adjustments that we have in the case. So the inflation adjustment really is sort of addressing all other. So that is using the full value of inflation.
Okay. And this might be a better conversation for the O&M panel, but I'm curious, is the overall O&M, the requested increase to O&M only 6% in this case?
What are the comparison points? How are you trying to measure it? I just want to make sure I understand the math.
Well, I'm just asking in the context of this statement that despite overall inflation of 13.5%, the company's O&M costs only rose 6%. So I'm just curious if the corresponding costs in the revenue requirement, what those corresponding costs, however they're defined for that metric, what the requested increase is here.
Yes. So the 6.5% is looking at midpoint of test year in 2019 to the midpoint of the test year 2022. So it's looking at 6% increases over that span of time. So it's not necessarily going to correspond to the expense increases we're looking for here because we're obviously projecting out to the midpoint of a rate year, December 2024.
Okay. Thank you. have some questions. I tried very hard to hear how you pronounced your name. I miss Gavrilovic.
Gavrilovic.
Gavrilovic. I'll try. I have some questions for you, Ms. Gavrilovic. Page 5 and 6 of your testimony talk about programs notifying customers about increases to their historic usage, that it's a conservation initiative. It sounds like the program is essentially if the company notes that that usage is increasing at some level beyond historic, that the customer is notified. Is there a level that kind of triggers that notification, a level above a historic range?
I believe there is. I'm just confirming.
Okay. 5 and it crosses over to 6. Sure. And I can take it as a read-in or
If you'd like to
supplement
move
or-
on, yeah.
Sure.
We can do that as a read.
Oh, yeah, I'm just curious what, if there's a triggering standard for that. And a follow-up question to that is whether the company has ever considered a similar notification program with a trigger based on average overall residential usage as opposed to subjective usage of the particular customer.
Are you referring to just kind of a standard across the board?
Yeah, I mean, I guess what I'm getting at here, that sounds like the system that's in place now is sort of notifying customers, hey, just so you know, you're using a lot more water than you normally do. Has there been any consideration of a system that says, hey, just so you know, you use a lot more water than anybody else?
I don't believe so.
Okay.
No, we have not done that. Our notifications to customers are primarily advising them of individual use. You know, we want to give them some signaling that, you know, from a billing perspective and from a conservation standpoint, there's an anomaly to what is normally seen in the given period. So that's where the communication to us has value.
Okay.
And that trigger is 150% of normal usage.
Okay. Thank you. And your testimony talks a little bit about the Miami Beach acquisition. There was some cross about that earlier today. I recall that part of the one of the issues that generated the petition in that docket from the perspective of the system prior to its acquisition was that it had difficulty obtaining permits to get some of the necessary improvements done. And the conversation in that docket involved the idea was that it was an aspiration, it wasn't a commitment, but there was an aspiration that subsequent to that acquisition that the company might have a better chance at getting permitting for those improvements. Just asking as a follow-up, has there been any issue with that? Has the company not been able to get permits? Has there been a change in plan in the capital improvements that are necessary?
I think what that permitting is likely referring to is replacement wells for those existing wells, which were not, but they did not meet disinfection requirements. What we're able to do is bring those sources to our existing Soundview treatment facility, which does provide 4-log treatment and essentially makes those wells fully available and usable.
Okay. Thank you. And Mr. Sobolewski was asking about the surcharge earlier. And I appreciated Mr. Dixon's response for the plan for that potentially to be credited back as a kayak. But the original plan in that docket was a initial investment of 5.85 million over the first 5 years and a total gross cost of service of 25 million. Is that roughly still the planning for that system? I'm talking about Miami Beach just for.
Can you repeat that, please?
Sure. In that acquisition docket, the plan proposed by the company was a $5.85 million investment over the first 5 years, which is part of a total gross cost of service of about $25 million. I was just curious if those numbers have changed since the acquisition was completed.
At least the 5-year plan still is pretty close to what we anticipate. We have a large distribution system replacement project ahead of us. So there's still some variability in what that final number looks like, but I think that 5-year number is likely accurate. I've got less confidence on the longer term figure.
Okay. I mean, as is true with any long-term figure. And just a follow-up, Mr. Dixon. So that's the idea of the surcharge is that when that around $5.85 million capital investment is complete, that's when the collected surcharge would be used as a contribution of construction against that figure. That's
the contribution aid of construction is actually reflected in this case. So Schedule B9, where all the kayak is listed, does have a line item for what has been collected from customers thus far.
okay, and that's of that 5-year plan. Okay, thank you. There was some testimony earlier about AMI and the projected deployment. I heard, I think Mr. Patla may have testified a rough $23 million plan cost to deploy over 3 years. Is that accurate?
That is.
Is there a reason? I'm just curious about the 3-year deployment plan, especially with regard to whether that involves replacing meters that haven't fully depreciated. Is the 3-year plan like an expedited plan, or would that be in line with the useful lives of the meters that are already in service?
Go ahead.
I believe the business case takes into account replacement of meters that are over 5 years old. So anything less than 5 years old would remain in place. The other assumption in that business case would be the technology. It would be utilizing Neptune, that is our current manufacturer of our meters. Part of the unknowns here is looking at all of the available technologies and making that determination on what would be the best technology given the various conditions throughout our system. You know, we're spread out across the state. Some areas have, services that are close together. Some are very spread out. Some have better cell service. Some would require some additional infrastructure. So there's a lot of considerations when looking at that entire business case as part of that.
Okay. So with that 5-year, 5 years is shorter than the normal useful life of the meters that are currently in service, correct?
That is correct.
So that $23 million number, does that include the stranded assets, the cost of continuing to pay the depreciation expense as to those meters that would be taken out of service?
No, it would not.
Does the company have a number on that, what that total would look like?
We don't at this time. It would be part of the calculus that would go into an overall design. This business case is not a design per se. It's basically giving us enough information so that we can make a business decision on whether to be go or no go to move it forward. And the next steps involved in that process would really make those determinations for us.
Okay. A few more follow-ups. I feel like I've usually going way over time, but I think we're okay so far. Mr. Sobolewski asked a similar question, Mr. Pala, so this is sort of a follow-up. It's about non-revenue water and the more or less consistent around 14% rate that the company's been able to hold. And you mentioned earlier that prior to the merger it was somewhere around 18%. My question was Ms. Gavrilovic testimony talks about the installation of the 1,600 leak detector monitors resulting in 3.3 million gallons saved per day in non-revenue water. Is that what moved the needle towards the 14%? I was just curious. Essentially, as I understand it, the companies maintained non-revenue water at around 14% pretty consistently, but also made this investment in these leak detection monitors. I was trying to tell, have those leak detection monitors been assisting the company in maintaining that 14%, or is that what got the company to the 14%?
I believe it's what got the company to that 14%, and now it's a combination of those monitors, plus our leak detection program, plus our production meter testing to ensure. So we're looking at both those real losses that are out there and looking at the data to ensure that we're reporting properly.
Okay, thank you. This is really just a clarification question. Sorry to talk about the toilet again, but that's another non-revenue water question about the leaking toilet. I'm just confused. I heard Mr. Patlas say that system might have a single meter sort of at the wellhead. I'm just confused how we're classifying a leak that's on the customer's property and under the customer's control as non-revenue water. Is it because that customer's usage isn't billed for volumetrically? Meaning, does the customer pay the same bill regardless of how much water the customer uses?
I would estimate that it's an estimation of what that actual leak was, or the gallonage associated with that. Just having the one customer, I would have to look further into it.
Yeah, and maybe I'm just not understanding, but I'm just confused. Like, if there's a leak at a toilet, why is the customer not paying a huge water bill for that leak? You know what but like, how does it get classified as non-revenue water as opposed to revenue water?
I would have to confirm on that.
Okay. So could that maybe be a read-in just for clarification on that? I'm not sure what going on.
F.
Okay. Thank you, Chairman.
Thank you.
I have a couple more follow-ups. There was a testimony earlier today about the COVID allowance for meter testing extended out to 2028. I was just curious if there's a rough, given that if you know a rough percentage of the total numbers of sort of outstanding meters that remain untested, acknowledging that allowance of the extension.
There was a percentage that was allowed as part of that approval and as part of that request for every year, what additional percentage would be tested. And I believe that was requested by the company and approved by Pura. I can provide that to you if you'd like.
Sure. You mean the approval?
The approval as well as the exhibit that lists out those percentages every year.
Yes, that would be, if you have that, that'd be helpful. And I'm sorry, is that something you can pull up right now or would?
I can, if you would give me just a minute.
Sure.
Okay, so, starting in 2022, the meters, there were an additional 10% of the meters, required from 2021, which equated to 476. In 2023, it was 25% of the meters required for 2022. In 2024, it was 70% of those meter tests required for 2023. In 2025, it's 80% of those meters required for 2024. In 2026, it's 100% of the meter tests required for 2025. And in 2027, 85% of those meter tests required for 2027. And in 2028, 90% of those meters required for 2028.
Okay.
I'd be happy to provide this exhibit if you would like as well.
Sure. Maybe the late file, if it's not already in the record. Or if that's an exhibit that's in a Pura docket, if you could just read the docket number, that would also work for me.
I don't believe it was in a docket number. It is a letter response from Pura dated November 28th, 2022.
Okay, so let's make that late file exhibit number 9, please, to provide the 11/28/2022 Pura correspondence regarding meter testing. Thank you.
Thank you, Chairman. I think the rest of my questions are about the lead service line replacement. There is a, testimony about the company performing company side service replacement when it's necessary. And it sounds like the plan is to whatever extent customer side service line replacement is incurred, those are going to be booked as a regulatory asset or a deferred accounting until the next rate case. Is that accurate?
Yes.
Okay. Is there any plant in this rate year for customer side capital expenditure? Plant. Is there any plant in this rate year associated with customer side lead service line replacement?
No,
Okay.
we would not have capitalized customer side replacement.
Sorry, company side replacement.
We would not have capitalized a customer side.
Okay. But it sounds like the company is currently, when it comes across lead service line on the company side, it's replacing that and capitalizing it like any other capital expenditure, and it rolls into plant and service, right?
Yes, that's correct.
Okay. So is any of the plant that's proposed to enter rate base in this rate year associated with company side lead service line replacement?
So the company side replacement generally would be as we come across it through a water main replacement project where we don't know a number ahead of time that is allocated, that is specifically related to a lead service replacement. It's part of the overall water main replacement project. So
Okay.
I don't know if we can directly map the replacement cost of that lead service to a defined line item.
Okay, but the company's seeking revenue in this rate case to compensate it for its costs incurred in replacing company side lead service lines, right?
I'm not aware of any replacements outside of WICA, so it would not be part of this application.
Okay, so those costs aren't in base rates, and as part of this application, those would just be in WICA projects?
To my knowledge, that's correct.
Okay, thank you. To the extent that the company does get any external funding for lead service line replacements on either side, what's the proposed rate making treatment for that external revenue? Would that be a regulatory liability?
Yeah, I think it depends what form the funding takes, whether it's zero cost loans or if it's actual funding, but it would be a reduction to rate base, however it comes in.
Okay,
Well, I think that if it's in the form of a loan, it would reduce the overall weighted cost of debt. If it's actual funding, it would reduce rate base.
okay. There's some testimony earlier about customer interest or lack thereof in the pilot. I was just curious about circumstances where where a customer, I guess, is the only way that a customer knows that they have a lead service line when they're approached in these circumstances when there's a project, or is there any kind of other communication from the company to notify a customer that they have a lead service line that should be replaced?
No, this oftentimes we don't know, and that is when they were notified by us, unless we come across it and make a determination, then of course we do notify that customer and try to convince them to a replacement. But otherwise, it's in most cases there's not good information on what that material is, as Ms. Gavrilovic testified to earlier.
Okay. I'm curious about the circumstance where a customer is notified under those circumstances, decides to do nothing about it, but then sells the parcel. The new owner, does that new owner have any opportunity to know that they have a lead service line? I mean, is there any kind of documentation that
I don't think it's a question for us. It's probably a legal opinion. But as far as the disclosure goes on a sale of property, if they have a known circumstance, I could opine on it.
No, I want to ask you to opine on that. I was just curious if the company has any record keeping methodology or anything to kind of keep track of, well, we know this address has a lead service line, and so that maybe in the long term, if there could be future communications.
Yes, when we make a determination that we have a lead service, we do note it within our records.
Okay.
And I do believe actually one of the one of the residents that accepted the offer to replace the lead service line was a new owner of a property. Realized that was the case, and it was kind of on that through that transition, reached out to us, and we offered that same deal.
Okay. Thank you. My last couple of questions are about the Water Infrastructure Finance and Innovation Act loans. I believe my understanding of the testimony from earlier today was that program doesn't only covers larger projects, and that's the reason.
I would have to confirm, but I believe that the the base for that is 25 million.
Okay.
And I don't believe that there are subsidies included with that. I believe that there's an upfront cost to that, to those loans, and there is not subsidy associated with it. The last that I've learned about the program, I'm not sure if there've been recent changes to it.
Okay, yeah. I was just curious if the company is aware that the EPA posts a list of closed loans under that program, and that list includes loans that are below that $25 million threshold.
I believe as part of that program, projects could be bundled and they could close on portions of it. That was my understanding.
Okay. Does the company kind of maintain any sort of documentation of its analysis of this program or other federal programs, any kind of documentation, any sort of documentation at all of the sort of decision that a particular program isn't applicable?
I don't believe we maintain documentation of it, but I do know that we are continuing to become educated on different programs as they come out or as we become aware of changes that are made.
Okay. That was my last question. And we have one more from Mr. Sobolewski.
In regards to Miami Beach and Soundview, I know there's the next big investment is to replace large sections of the distribution system. Is that correct?
That's correct.
Is the decision on whether town sewers are going in slowing you down in those systems?
It is not, that still is not a well enough defined initiative in that part of the state to plan around. And truthfully, there's plenty of space in those streets for us to locate the main as appropriate and let the sewer project, should it materialize, work around us.
Okay. And just one follow-up on PFAS. Is there any new estimate of when the federal regulations are coming out?
All indications were that they were going to be out in December of 23, and we have not seen anything yet. So any moment?
Okay, that's where any second something could happen that we.
Yeah, and we've gotten indications of what the levels will be and that it'll be a 3-year deployment for installation of mitigation treatment. But it's at this particular point is late.
All right, thank you. That's all I have.
That's all the opposite.
Thank you. Attorney Real, that was exactly 1 hour and 15 minutes. Okay, let's move to Attorney Dichter, please.
Now it's on. Hi, I'm Joel Dichter. I represent the Heritage Village Master Association, which is a 55+ community of over 2,500 condominiums, as you no doubt already know. I have a few areas that I'll touch on quickly. The first one I want is I sent out an interrogatory about safe yield for the Heritage Village system. I just have a question or two on. That was HV 8. Pull out my reading glasses. And in there, it says that Heritage Village sources 2.330 million gallons per day and has a safe yield of 3.053, which does the company consider that to be an adequate safe yield for the system?
Under present conditions, it is adequate safe yield, yes.
Okay. I have a question though. It says that includes 0.5 million gallons a day through the Middlebury interconnection. Is that part of the Connecticut Water Company system?
Yes, it is.
Okay. Are there any limitations on the availability of that additional supply through the interconnection?
It's the 500,000 gallon a day is the diversion permit limit for that source.
Okay, so there are no conditions in which it could be interrupted or if as needed?
Yeah, that supply is available to us as needed.
Okay. Are there any plans for any new wells or sources of supply for the Heritage Village system?
We do not currently plan any new sources of supply within the Heritage Village system. We are looking at long-term planning opportunities to convey supply from other locations to help supplement that long-term availability.
Say about new interconnections to the system from other sources.
Potentially, or revisiting that 500,000 a gallon a day diversion permit limitation to see if a higher permit threshold would be approved.
Can that interconnection handle more than 0.5 million gallons a day?
There's one pump station along the route that we expect would need an upgrade to be able to achieve that, but otherwise, yes.
Now, the Heritage Village system has had a non-revenue water percentage of around 15%. I think that was the number. 14.9% was the number for 2022. Do we know the number for 2023 yet? Is it available?
We're confirming that answer. If you'd
Okay.
give us just a moment.
Sure. Hopefully this pause doesn't count towards my 10 minutes.
Should just take a moment.
It's no worries.
Sure, we can read it in.
Sure, so that would be read in G. If you can, Attorney Dictor, just please remind me briefly of the prompt.
The non-revenue water percentage for the Heritage Village system for 2023.
I apologize. Stop the presses. It is 18.2%.
Very good.
The 18.2%?
That is correct.
Okay. And do you have an explanation for the increase, substantial increase from the prior year? I'll restate the question if you like. Do you have an explanation for the increase of the 18.2% from 14.9% for 2022?
I think we would have to take a look at the data and review that and before answering that. Much of the system is unmetered though, so it is an estimate.
Well, so, you know, it's an estimate. What do you mean by it's understand that a large part of the end users are not metered, but you still know the amount of water delivered into the system, but you don't know the amount billed.
So so knowing the amount that's going into the system, again, not having specific meters, not knowing exactly the amount that is going through those meters on the distribution side, it's challenging to determine how much water is unknown, is a loss.
And how have you estimated it in prior years?
There's a given volume attributed to each unit of the association. The balance is what's metered outside of the bounds of the Heritage Village Association. The production number has gone up. The same numbers characterized as a constant for the unmetered customers is carried through. And then there's there's a reduction in the metered customers' usage, creating that delta of the 18.2% prior to the prior year.
But you would like to have that number lower, and do you have any plan to make it lower? Have you
Well-
put in the acoustic listening systems in the Heritage Village system, for example?
We have not put those in Heritage Village. The Heritage Village has the distribution lines are plastic. It's challenging to locate them. It's challenging to make those determinations on where the leaks are. It's a struggle. And those lines were there prior to us acquiring the system.
And I believe you acquired the system in 2017. Sound right?
Yes.
Do you know if there is, so are there no lead service lines in Heritage Village?
I believe there is not. I believe they're all plastic mains.
And there's found to be no PFAS to date in the Heritage Village system, is that correct?
Subject to check, I think we have one well that subsequently was tested with positive PFAS.
Could you provide as a late file exhibit some details on that finding?
Yes.
Late file exhibit on finding of PFAS in the Heritage Village well system?
Well 2 at Heritage Village has had detections for PFAS.
Do you know if they're above the 0.4 limits or
It was above.
was above? So treatment is required.
Not necessarily. It would depend on how you operate the combination of those sources and how the regulation is written and the point in the process where the threshold applies.
Okay, Attorney Dichter, are you withdrawing the late file request or are you looking for?
No, I still would like the late file request. I'd like to know the results of the finding, what the level determined was to be.
Okay, so that's late file exhibit number 10.
Thank you. Last subject. We've heard something in the Heritage Village system, there is an issue with manganese in the system. Is that correct?
There's been a historic manganese issue in the system, yes.
And you are proposing a treatment facility to be put in place to remove the manganese?
That's correct. The facility contract has been awarded and construction is underway.
Okay. I believe in response, though, it was said that it wouldn't be completed until end of 2025. Is that correct?
Correct.
It's a 3-year process to build this plant?
Well, I'd say 2 years since we're in 2024, and it'll be wrapped up by the end of 2025. So approximately 18 to 24 months.
Well, I said that because the design was completed in December of 2022. And
Correct. If you count the design phase, yes, that's beyond 2 years.
so is there currently manganese in the water being served to Heritage Village residents?
Operationally, the wells that have the lowest levels of manganese are prioritized for use. The completion of this treatment facility will increase the available yield under all operating conditions and have all those sources delivering supply with low levels of manganese.
But currently there is some level of manganese going to these residents.
My understanding is the well that has the highest manganese would just be, the use of that would be minimized so that the manganese is being minimized, being sent into the distribution system.
You know which well number that is?
I think it's well 2.
Same well as for the PFAS. And is that well currently supplying water to residents?
It's available to supply, yes.
And does that have an impact, taking that out of, if that was taken out of service, would that have an impact on the availability of supply to meet the needs of the village?
Yes, it would.
And you know, where that health concerns have been raised with the supply of manganese for drinking water purposes to residents. Are you aware that
Can you
of
repeat
that?
the question?
Yes, are you aware that there have been concerns raised about health impacts of supply of manganese water to the public for drinking water purposes?
I'm aware that in general, there is concern over manganese in the drinking water supply, yes.
Would it be possible to accelerate the implementation of that water treatment plan?
I don't think that's realistic.
Thank you. That's all I have.
Thank you. Attorney Wright. Thank you, sir. Attorney Inoue. All set. Director Lopez. Okay. Commissioner Karen.
One question, going back to the pilot program, the lead pipe pilot. You mentioned that the cost for customer side remediation would be something $3,000 to $5,000. Did that come with any type of financing, or is it just cash in the barrel?
Yes, there was financing associated with that. I believe it's a 1-year timeframe with that spread over 12 months on customers' bills.
Okay, well, okay, thank you.
Okay, no questions from the Vice Chairman. I will pick up here. I think we're at an hour and a half from our last break, so I'm going to keep going and see if we can finish my questions before we break and consider redirect. Okay, I have a couple of questions based on other questions that have been asked today. Let me backtrack to a question from just a moment ago. The Attorney Dictor was asking about the treatment facility. There was a response that there's a treatment facility being built. And my question, I didn't understand in the exchange whether the technology being employed in that treatment facility is capable of also removing PFAS from the water, or if this is a treatment specific only to, I think it was at manganese.
Yes, the treatment is specific to manganese. PFAS treatment would be the treatment is specific to manganese. There would be additional treatment required for PFAS removal.
Okay. Out of curiosity, is there any technology on the market today that that targets multiple contaminants?
The challenge is the chemistry of the removal mechanisms sometimes compete with the different contaminants you're trying to remove. So for example, if you're using GAC to remove manganese, the sites on that granule get occupied by the manganese and no longer would be effective for PFAS. So if you have the presence of chlorine, that can impact whether or not the media can bond with the PFAS. So it takes an individualized assessment for each water quality that's coming in and the treatment that's in place. That's part of what the master plan that we're putting together is to account for all those variables and determine what the best treatment approach is.
Okay, that's really helpful. So am I to take that response to mean that there are going to be situations in which you have to choose between treating PFAS or manganese? Because when you're talking
Or
about the
it
molecular.
would be more that there would be a separate treatment process to supplement the manganese removal process. There would need to be a second process in series for PFAS removal, as opposed to depending on one process to accomplish both those objectives.
Okay, so any prioritization that takes place is, well, let me say, is there a prioritization that takes place in assessing whether, like if you had a limited amount of capital, and in this case, you're talking about deploying a treatment center to address manganese, but I think I heard that there's also PFAS in the same well. So if, let's just assume for a moment you had limited capital, is there an internal protocol for how you assess which treatment to deploy first? Is PFAS considered more emergent than manganese, or is it just?
The process we would use would be the same process I described about assessing risk to the customer and benefit to the customer achieved by the treatment that we implement. For this specific situation, manganese and the water quality in the distribution system has been an identified need that rose in our priority to be addressed. Remember, the PFAS requirements still don't officially exist. And in fact, that water sample we're talking about is very recent as well. So as PFAS is better defined on what the regulatory requirements are and how it will be treated, and our implementation timeline, that would become part of the formula as we go forward and look at treatment solutions, whether we should be prioritizing PFAS versus other contamination.
Okay. And all right. Thank you. So speaking of water quality, I just want to backtrack to some exchanges that you had with various parties today about water quality, and specifically the water quality issue mentioned at the Ellington public comment hearing. My recollection was that that was a bit of a theme from that public comment hearing, the theme being water quality issues. And I just wanted to make sure, let me start there and ask whether the company was intending to qualify the number or type of comments on water quality that it's received in this case at public comment hearings.
I would say, at the public hearing, there were more than one comment about manganese in the water. And when we did the follow-up with them, we didn't necessarily see that. And we communicated that with the customers. There were as well a number of comments about a chemical type of smell. We see that often if related to chlorine levels in water, and especially when in the summer months when we're carrying a higher chlorine residual out of the plant. So we think that's probably at the bottom of what many of the comments were and for where they were from, which are immediately, pretty close to the discharge of the plant. So it was hard to gain a pattern from the comments at the hearing, other than to say we did run them all down and had conversations with those customers afterward. And so from a pattern development standpoint, it's hard to see. We certainly don't see a pattern of calls that are coming into our call center relative to the water quality. And these are primarily secondary standards, taste and odor. And we're just not getting the volume that the hearing itself would suggest.
Okay, thank you. So to say this back to you, the way in which the company chased down the complaints was that the customers that you identified at the public comment hearing, you followed up with a conversation. Did you pull their records and see if they had called the company? I was just looking for a little bit more detail about how you chased down the complaint. Of course. And I recognize we have a customer complaint panel later. My questions are going to circle around to like the specific treatment of water quality. So that's why I'm seeing if we can address those here.
So we had their name, we took their names at the hearing itself and reached out to them in the days following. The content of that reach out, I check for you.
Okay, thank you. I can circle back around to the customer complaint panel, which I think comes, or the customer experience panel, which might not be until next week. So, just to, just a preview to whomever's on the witness on that panel, I'm going to be interested in understanding any internal policies around outreach to customer complaints. So on the water quality issue, though, how does the company identify water quality issues other than the receipt of customer complaints?
We do regular distribution sampling as required by Department of Health. So those requirements we do bacteriological testing as well as physical sampling, which is all the potability metrics, taste, odor, metals, pH, that type of thing. And there's a prescribed number of distribution samples that are gathered depending on the size of that distribution system. Yeah.
Thank you. And is manganese one of the contaminants that is tested for?
It is.
Okay. So when we talked about the pattern earlier, I'd like to get a sense from the company on the water quality issue, how you might identify patterns from the distribution system testing that would lead the company to instituting a treatment plan based on a pattern that you might have identified during the testing. Is there a threshold of the number of, I don't want to call them violations because that may not be the right word, but exceedances of standards or?
Yeah, there is a secondary standard for manganese right now. There's a proposal right now for a primary standard for manganese, which would entail a maximum contaminant level. But the secondary standard is what we utilize now to determine if we institute treatment at any of our sources. And typically, iron and manganese follows along with our groundwater sources of supply as a naturally occurring element within the structures of the well, typically the bedrock wells. And we measure that at the point of entry from the treatment facility out. But we also measure the raw water quality too to make sure that we have the appropriate treatment in place if required.
And if I might add, just from the from our sampling, we monitor trends. We look at if we find something that is, a trend is forming, we take a look at that data and analyze that and make that determination. The Chester Village West, for example, where we included provided the treatment for uranium, that was, increasing over time. So that project was planned and installed.
Okay. So thank you both. So like in the gas world, there's like a matrix of leak classifications and like the grade of the leak and that's used to facilitate the type of replacements or the risk. Like I'm trying to unpack whether there is a similar like risk matrix here that the company uses where you have emerging contaminants, water quality issues, non-revenue water, like is there some kind of matrix that you use to assess how you're going to deploy or like which projects you're going to tackle first? Because whether it's a capital restraint or just simply a labor restraint, you can't do everything at once, right?
That's right. And it goes into the capital planning tools that Mr. Peeling was referencing earlier. But let me just say that compliance is at the top of that prioritization. Non-compliance is we cannot be non-compliant when it comes to the delivery of water. So in the case of PFAS, that's why we're anxiously awaiting the rule so that we can begin to put it into place our capital additions so that we don't fall out of compliance at the end of that year 3 with manganese as well. Now, manganese as it sits today is a secondary standard that falls below a primary standard, but is still a compliance metric that falls at the top of any matrix, as you suggested, of prioritization hierarchy for us.
Okay, thank you. So transitioning a little bit, but sticking with maybe more emerging contaminants, does the company or your parent company allocate a percentage of non-ratepayer dollars to conduct research and development into the treatment of emerging contaminants?
One of the, we're part of many associations. Connecticut AWWDA is more on the technical side that would be addressing emerging contaminants and types of treatment associated with it. We are also members of WRF, which are AWRF is the acronym there. That is the research wing of that same association, and they are we take advantage of what their findings and studies are to help formulate what our decisions may be around the treatment of these emerging contaminants, and we maintain that level of membership and participation in those associations, and as well we count on consultants as well for their knowledge and their more in-depth knowledge on the specifics of what a particular treatment process may be. And I've turned to Mr. Peeling to see if he had anything further on that.
No, I think that's those are the best research efforts that we support.
Okay, which are currently funded in rates. So ratepayer funded. Okay, thank you. So OCC during their cross asked the company was aware of any customer complaints about PFAS, and I think the company answered, if I understood the testimony, the answer was no, but that there may be inquiries. Correct me if I'm wrong, and I'm not going to ask any questions about the lawsuit, but the company is being sued with respect to a PFAS complaint currently, correct?
That's correct.
Okay, so your response earlier, the company does not view that lawsuit as a customer complaint about the presence of PFAS in the system.
When asked the question, I guess I was characterizing it as complaints from specific customers coming into our call center. But by definition, as you suggest, maybe the lawsuit could be considered a complaint.
Okay, thank you. I have a few questions about non-revenue, well, about the non-revenue water percentage. So when you acquire a system, I'm sorry, let me ask a foundational question. Is Miami Beach the only system that was acquired since your last rate case?
Yes.
Yes, okay, thank you. When the company pursues an acquisition of a system, are there internal guidelines or protocols that are followed with respect to the non-revenue water percentage, the water quality, the inventory of like their lead service lines? Are there any internal protocols that you look to have those boxes checked, like when pursuing a voluntary acquisition?
Yes, we will look at all of those operational variables as they would ascribe costs incurred to our existing customer base. So in the case of Miami Beach, all of those operational encumbrances were certainly considered as we went through the process of voluntary then involuntary as part of that overall decision process, because the costs were going to be significant as we looked at both the short term and the long term. Ultimately, through the process, it was determined that a surcharge is more appropriately because of those costs. But certainly, if we're looking at a system for acquisition, and there have been many that have come knocking at our door to say, "Hey, would you like to take this over?" When we do our due diligence and our inspection of the system, and we did this many times through the years with Miami Beach, we just simply say no because we can't incur the costs associated with getting those systems up to compliance on the backs of our existing customer base.
Thank you. I think you've anticipated my next question a bit. I'm just trying to ascertain whether there's a threshold that's exceeded in any of those categories, non-revenue, water quality, lead service, and any factor that you look at. If there's a threshold that is exceeded, that would make the company step back and think, it's not prudent to acquire this system because the operational needs or the operational expenses of bringing the system up to compliance on the backs of all of our ratepayers would be too much. Like, I'm trying to figure out if there's some kind of line that the company has internally.
A specific threshold, we do not have but typically our concerns primarily revolve around compliance, and that leads us typically to the doorstep of the water supply, as it did with Miami Beach. And, if what it takes to get a system into compliance is a treatment facility or an extension of main from an existing system of ours, that is out of scale with the number of customers gained. And you're going to ask me what that definition is, and it's really hard to put a finger on exactly what that is, but we wouldn't necessarily take that on. And as I said, there have been many situations where we've just said, no, we just can't do that. But putting a specific threshold number on it, though, I can't say that we do.
Okay, thank you. So there have been a number of acquisitions that have occurred. I think I read in your 60 years, I'm going to conflate the numbers. So there's been a number of acquisitions that have occurred, albeit only one since the last rate case. I guess where I'm going with this question is trying to understand there's a point in time at which future upgrades to the acquired system are then socialized rather than added into the surcharge that may or may not have applied to that system. How does the company think about these smaller systems that have been acquired that continue to be out of sync or in excess of the non-revenue water percentage? I think your merger commitment was 14%. So there ever been a thought that a continued non-compliance with the non-revenue system percentage justifies any other treatment than socialization?
Well, again, typically the small systems and the seemingly higher number on the non-revenue water percentage would typically equate to a smaller volume of water itself, though. So like in the case of Christ Lutheran, 60% of 5 gallons a minute is very small. And so we actually prioritize our resources based on a volumetric number together with the percentage. So it's for a triggering of a deployment of resources, it's yes, the percentage is a variable that's looked at, but as well, we're also looking at the system and the percentage to which that and the volume to which that percentage is ascribed to deploy our resources. So the betterment of and I'm just gonna grab one, a Bay Mountain, for example. You may look at that year over year and say, why aren't you deploying resources to fix that? Well, that's not to say that we haven't, but we don't deploy as much resources as we do to the larger systems where volumetrically we're going to get more benefit to the customers by finding those larger leaks, fixing them, and saving the O&M associated with it.
Okay,
Yeah.
very helpful. Thank you. I have a quick question about GIS, and I think it was in Ms. Gavrilovic's pre-file testimony. So there's some references in around page 9 to the company's investment in the use of GIS mapping. And my question is, if you could just elaborate a little bit on the operational efficiencies that the company is hoping to procure from GIS. I think I saw in Mr. Peeling's testimony a reference to mapping being a couple $100,000 a year, but I may have that wrong. So I'm trying to figure out what the cost benefit of the investment in the GIS is and how the company thinks about using it to achieve additional operational efficiencies.
Sure. So the recent upgrades in our GIS system have been very helpful to us on the operation side for a multitude of reasons. We use dashboards to now track our hydrant testing, for example, so that we're able to efficiently test our hydrants, make sure that we're in compliance, that we test all of the hydrants. So we track that way. We also use our GIS dashboard to track our flushing operations so that we're able to efficiently take our flushing program, methodically, flush our system. Customers are able to see where they're, if their lines are being flushed, be aware of what's going on in their area. So when they call in, it helps our call center representatives. We also can map water quality issues in real time. If we're getting complaints, we can focus on that, see what area where we need to deploy resources and to address any issues that may come up. Also, with our GIS system, we're able to, GIS, so those upgrades that have been made, we're able to more accurately locate our hydrants, our valves, and be able to address, for example, a water main break. If our crews get called out to a main break at midnight, and it's dark out, they're able to more accurately find those valves, shut down the main, and more efficiently repair it. So it's less time that they are called out, less time the customers are affected by the main break. And it really, we gain all of these little efficiencies by those upgrades that have been made to the GIS. Additionally, our customer records and our tap cards, so we're able to locate services. Previously, it was paper tap cards, so you're taking measurements, kind of looking for those fixed points of measurement, and now it's much more efficient and easier to locate all of those things in the system.
Thank you. I appreciate that comprehensive answer. In the first part of it, you touched on where I was going with this question. There's some customer issues brought forward, I think also in the Ellington public comment hearing, I may be mistaken, from elected officials regarding the fire hydrants and the testing of it. And my question is, recognizing that GIS has sensitive information in it, has the company given any consideration to providing access in real time or after the fact to elected officials or perhaps our call center to take advantage of some of the efficiencies that you noted? Like, would the elected officials in those towns be able to see their fire hydrants, their schedule? Is that something that you've considered?
We have, what we have done is we have not granted access per se of all of our towns to our GIS system. We have provided information to them. We've provided paper copies and we've provided other information that keeps sensitive information still just within the company, but we're also able to give them some additional information so that they are better able to know, what those assets and infrastructure is in their towns.
Is this a new initiative?
There are, when you think of a GIS, you think of the baseline mapping. And then all the attributes, all of the information then goes on top of it. And that information goes on top of it in the form of what we call layers. And what we'll do for a fire department, for example, is we'll provide them the fire hydrant layer so that they can take that layer and insert it into their own GIS system. And then it's available to their emergency services, their towns and otherwise. We also provide information in the form of land records, that type of thing. Avon, for example, we're doing that with. So there, upon request, we can provide layers of information as long as it's not sensitive information, customer base or otherwise. But certainly from an infrastructure standpoint to the point that it benefits the town, we like to work with them and provide them the layers that they can then insert on within their own GIS system.
Okay, thank you. I'm just going to ask for a late file exhibit, which I think we're up to number 11. And specifically, I'm looking for a description of the GIS information, the layers, and the frequency of which the company could provide this to elected officials or fire departments. And just trying to understand like a potential formalization of the provision of the information. Is that?
So is the request, how often we could provide, is that an implementation description you're looking for, or a frequency that we could potentially share static updates on what is?
The latter. So recognizing that the granting of real-time access may not be appropriate, and reacting to Mr. Patlow's statement that this seems like it's historically been done on a more ad hoc basis. I'm looking essentially for a company proposal on how what could be provided on what frequency to elected officials, fire departments, whatever the appropriate entity is, to address some of the customer complaints that we've heard in the proceeding. Is that
Understood.
clear? Okay.
Thank you.
All right. Thank you. One last GIS question, please. Ms. Gavrilovic, does the company's GIS system, has it taken into account any state designations that may be available through the state's GIS mapping, such as defined underserved communities, environmental justice communities, other layers?
I don't think specifically those categories are represented, but we often incorporate state layers into our GIS as beneficial to our daily use. So that's certainly something we can add.
It could be added.
Absolutely.
Can I just understand briefly the cost associated with adding a layer? I won't hold you to the estimate, but like, is this?
If it's an existing data layer from the state, it's a very straightforward process.
Transmittal of
I
data.
bet our guys in a week would have that in and ready to go.
Okay. All right. Thank you. Can I ask some questions about AMI, please? And Mr. Patlow, the first question is just clarifying, and it's perhaps my ignorance about the difference between AMI and the different types of sectors, but at one point earlier today, you referenced the 25,000, I think you said AMR/AMI, and I just was trying to clarify, is there something such as a bridge meter in the water space? Or were you just saying that that 25,000 is comprised of some portion of AMR and some portion of AMI? Does that question make sense?
Yeah, absolutely. Some portion of that 25,000, I don't know the number, are of an older generation of what's called an MIU. So an MIU is basically a transmitter that's mounted on the outside of a home that's wired to the head of the meter. That transmitter that's mounted outside transmits readings when we, as a meter reader, walk by or drive by, when we wake it up with our own instrument. It'll send a meter read to us, we grab it, and off we go. AMI, now, there are, again, another portion, a newer generation of those same MIUs that are, that they will migrate from a walk-by, drive-by AMR platform to an AMI platform, and they are usable in an AMI format. So in other words, those assets would not be stranded if we were to go with that particular manufacturer's platform. We could utilize those transmitters as part of it. And I don't have the breakdown of exactly how many we have that are that migratable newer edition.
Not a problem. You've answered my question. Getting into the business case a little bit, just a very basic question. Does the business case, similar to a question earlier asking if the undepreciated meters were accounted for in the business case, I think the answer to that was no. Does the business case evaluate the operational efficiencies and cost savings that the company would seek to achieve with the deployment of AMI? Or is this more of like, I'm just trying to, maybe a better way to ask the question is, what do you mean by a business case? What in your mind are you?
It does, do you want to answer?
Sure. It does take the costs and benefits into account, but there are different technologies, different manufacturers out there. So this is specifically based on a hybrid system, which is a portion AMR, a portion AMI of the Neptune, the manufacturer of Neptune.
But it does take into consideration what the potential O&M savings could be. Reduction in truck rolls, for example, reduction in customer calls. All of those O&M efficiencies are considered as part of the case as could be gained efficiencies. So we're looking at even conservation through the ability of a customer or ourselves to be able to see anomalies in use patterns of given customers or even given sectors of our overall distribution system. We would have that instant notification of an anomaly that way. Whereas with quarterly billing, we not see that for potentially 90 days. Reduction in truck rolls, reduction in accuracy of bills. All of those things are considered in the overall business case for potential savings that are based on primarily on industry trends and what's been seen by companies that have deployed AMI within their companies. And it's, candidly, the savings are substantial.
Okay, thank you. So I'm going to ask this question here, although I guess it could equally be asked to the plant additions panel. I think we have the same witnesses. So let me just stick with the AMI question for a second. So I'm trying to figure out what exactly the company is looking for in terms of the instant proceeding or moving forward. Like, I think it was Mr. Peeling's pre-file testimony that may have included like a high-level breakdown of the types of capital expenditures you've made over the past 4 or 5 years. Looking at that, it looked like maybe you were investing $500,000 a year in meter replacements, rough math. and then 23 million divided by 3 years, roughly 8 million. Like, I'm trying to figure out if you're trying to set us up for suggesting that you're going to need like a follow-on case to make some kind of business case presentation for AMI, what the timing of that would be, if you're looking for some kind of nod here, like certainly the company has the ability to invest in AMI absent, pure pre-approval. So, like I love the conversation around AMI that we're having, but I'm just not sure I have my hands around like what the ask is, if any.
Well, I think the ask right now is maybe not an ask at all. Just that we're advising on where we are in the process. I think in the past it's been signaled to us that AMI may not be necessarily to the benefit of the customer, and I think the technology has advanced to the point where I think that that's no longer true. And I think the business case talks about what those benefits to the customer can be through knowledge gained by the customer of their own use patterns, but also secondarily as savings through O&M efficiencies that we just talked about. So I think what we'd like to do is perhaps in a separate proceeding or a technical session is present that business case and where we think we're going to go with it, and potentially how we could propose of how to fund it.
Okay, thank you. So there's no funding request here, although implicitly baked into the revenue requirement are replacement non-AMI meters.
Yes. Well, all the meters are AMI. They can all be AMI compatible. The AMI system needs to have a transmitter attached to the meter. So the meter replacement program will continue. These meters are migratable from our current method of reading to an AMI solution.
With a meter collar, essentially. Or are you saying that the hardware is the hardware, you need the software?
I'm talking about the meters themselves.
Okay. Okay.
The meters would need a MIU radio that would collect the data from the meter, and that would transfer it to the software. Depending on that infrastructure and the area, whether we could utilize cellular or we would need to install towers to be able to collect that data and then transfer it to the software. It's going to depend on different parts of the state. So our next step would be to look at the different manufacturers, look at what's available through each of them, put a solution together. I think, as Mr. Patla mentioned, what the business case gave us was yes, this is a good investment. That takes us to the next step of further investigating to see which technology would be best suited to our systems and propose that path forward.
Thank you. I guess what I'm ultimately driving at is whether there are any costs being requested in the instant revenue requirement that would be explicitly duplicative or rendered inefficient. Like, for example, easy example, stranded meter assets. So I don't have a sense from the company what the timing would be of this theoretical follow-on proceeding, or if it's just going to be baked into your next rate case. So I'm trying to get a sense of the instant revenue requirement and how we should think about that in light of this potential follow-on case.
So the recovery request as part of this case is primarily the hardware associated with new radio installs for for now, AMR usage, but with compatibility and technology that would also be suitable for AMI use. So certain circumstances like a meter pit or a difficult route or customer request, these meters will be deployed. They're usable in the future for an AMI system, though for now they're being used in an AMR capacity. And that's the limit of our request as filed with this application.
Okay, thank you. All right, I'd like to transition to questions about conservation expenditures. So the way I read Ms. Gavrilovic, your pre-file testimony was that I should think of the company's conservation initiatives in two buckets, ones that are maybe system facing, which I take to be covered by your testimony, and ones that are customer facing, which I think I should direct to Ms. Williams. Let me first ask if that's a fair characterization of how I should think about splitting these questions.
Yes, it is.
Okay, very good. So I know we've talked about in that framing, can you tick off for me the buckets of expenditures that are system facing that fall under your purview that you would classify as conservation expenditures, please? Like non-revenue water expenditures, I would assume are up there, but are there other buckets?
I believe that. I believe that that would be it. The acoustic leak detection monitors associated with non-revenue water.
Okay. Okay.
Yes, I believe that's it.
Okay, very good. So RRU 108, and let me pause and let you get there. Okay, so my takeaway from this response was that some capital improvement projects, one of the justifications for those projects may be efficiency, attempts to gain operational efficiencies. Is that a fair characterization of the response?
Yes, that's accurate as one of many factors.
Many factors. Okay. So with that in mind, my question is, how do you project from the outset what the operational efficiencies may be from these types of system-facing conservation expenses, and how you essentially measure the realization or lack thereof of those projections?
It's a good question. We're trying to figure out a good answer for that. What we run into is many of our capital projects include components that provide operational efficiency. So a more efficient pump or a variable frequency drive as part of a larger project. So we know qualitatively that's going to produce savings. It has value. It's worth incorporating into the project. It's difficult sometimes to quantify what that benefit is going to be because conditions change. It's part of a larger project. We might only have energy usage data for an entire facility, and it's difficult to map that back to an individual component that isn't separately metered. So there are other benefits out there that we have no way to measure right now. Distribution system improvements through WICA, that reduces the energy required to pump water through our systems, but how do we quantify that in a realistic way? So it's going to be some combination of assumption, some baseline data, the improvement type that gets us there. But right now, unless it's something that very specifically reduces or eliminates energy usage, like a couple of our projects, like the lift station combination project in Heritage Village, where we can say we eliminated these stations and all costs associated with that goes away. It's very easy to quantify that before and after. But if it's mixed into a larger project, we still need some methodology development there.
Thank you. So one quick question, follow-up. So I take your point about quantifying being easier to do when it's an energy-based operational efficiency. Are there other types of operational efficiencies, like reduced water or reduced? I don't want to speculate. Like I want to make sure we're not talking past each other and that we're on the same page about what you mean by operational efficiency, so I can rephrase my next question.
I understand your point. I was speaking specifically to energy, but we do consider those factors as well. Our Williams Water Treatment Plant project, one of the big advantages was we could add a recycle capacity that returns up to 10% of our disposal water to the head of the plant and reduces withdrawals from the environment. So there's energy benefit, there's supply benefit. We have many projects that offer operational benefits to our operators or safety improvements or reduce the number of trips. So all of that would be part of that operational efficiency that we would consider.
Thank you. So I'm going to ask for a late file, and I think I only have 2 questions after this, so we'll take a break in just a minute here. So I have not seen this question in another interrogatory. Please correct me if it's already in the record. But essentially what I'm looking for in a late file is a description from the company of the metrics, system-facing projects, the metrics that can be or are already being projected and tracked in the operational efficiency bucket. So I can try to say that clearer.
Can I ask, are you suggesting by category or specific project by project, what operational efficiency elements were considered, or what would be useful?
More the former. I thank you for the clarification question. I'm more familiar with energy efficiency programming and conservation spending in the electric and gas space. And what I'm trying to analogize this to, and perhaps it's not appropriate, is that when you're developing a portfolio of conservation spending, whether it's grid facing or customer facing, you might say, well, I'm trying to achieve X number of megawatt hour savings by deploying X number of measures. And then you go back and you measure against that. And I think that there is an analogy there to the water sector where I'm trying to see if you can project and then measure operational efficiencies for system-facing projects. It's not specific to any project in particular, but maybe what you might look at when you're evaluating the validity of expenditure. Again, any clear?
I think I understand it, as long as it's a little more open-ended discussion and potential steps. I think we can put something together like that.
Thank you. And the company can caveat, like if you do or don't recommend it or whatever. I'm just looking for what could be done if you'd be willing to do it. If you think it's a bad idea, just looking for a response here. Thank you. Okay. Mr. Patlock, a quick question. It's another late file exhibit. I didn't hear Attorney Wheel actually ask you for the delegation of authority document as a late file. If he did, I missed it. Sorry. But I would actually ask as a late file exhibit the formal delegation of authority document that was referenced in your pre-filed testimony.
Yep.
Okay. So that's late file exhibit 13. Last question, just a clarifying question. Is this the first rate case proceeding in which the company is being asked to demonstrate compliance with the merger terms, so like terms, I'm just trying to get straight in my head the timing, like the merger was docket number 1904-02, and then you had a rate case 2012-30. So from the company's perspective, the settlement agreement terms that were memorialized in 1904-02, is this the first opportunity in which the company is being evaluated on, I don't know if evaluate is the right word, being asked to demonstrate compliance with the merger agreement, or was that a factor in 2012-30 that I'm not recalling?
I believe it was a factor in 2012-30, but subject to check, honestly.
Yeah, some of the commitments are one-time commitments. Some of those commitments are ongoing. So first, we do submit sort of the annual compliance with the merger commitments, and that is all inclusive of all commitments. But as part of the last rate case, one of the most important ones as part of that rate case was a demonstration of synergies. So that one got a lot of attention in the last rate case where we needed to provide $300,000 of annual savings to customers. So we demonstrated that there was $1 million built into rates. We continue to do that as part of this case, but it did get that attention in the last proceeding as well.
Thank you. So specifically for the purposes of this panel, I'm focused on the merger agreement. I think a term that has maybe already been discussed today, it was the term regarding the advanced water loss reduction and acoustic leak detection sensors. So if I'm not mistaken, the term or the finding or the commitment was that the company was planning to install acoustic leak detection sensors to provide daily notifications of potential leaks, to also use those technologies to discover pipe leaks. And coupled with that is a commitment to use your new parent company's experience and technical expertise to reduce non-revenue water to less than 14%. So just a basic question here as to whether Mr. Dixon, in the characterization that you just provided about one-time versus ongoing commitments, to the extent you agree with my reading of that merger agreement term, do you view that as an ongoing commitment that is governing this proceeding? Specifically the 14% non-revenue.
Yes, we do.
Okay. Give me 1 second. I think that's it for me. Just let me triple check here. I had a question about lead service line replacements and WICA. I was doubting whether that was more appropriate for a WICA panel leader. But let me ask it here, and if it's not, and you can tell me to ask it later. But there was an exchange, and I apologize, I can't remember if it was with OCC or Mr. Dichter, but there was an exchange about lead service lines and whether they found their way into rates. And there's an exchange, and I think the response was like, no, those are WICA. Maybe this is a silly clarification, but WICA is eventually judged for prudence and rolled into base rates. So is this a distinction without a difference? I just want to make sure I understood the response, if you recall.
Yeah, I think first, everything that's been approved through a WICA docket up to this point is being rolled in. So it is part of this case in that respect. There are no new WICA projects being considered here, but everything that has been captured in the WICA charge thus far is here as part of that ultimate prudency determination that you spoke to. In terms of the fact that there could be, or there are service line replacements as part of that WICA investment, I think the answer is yes, that those would be in there. And I'd let Mr. Peeling to speak more to that.
Yeah, I agree with that assessment.
Okay, so those were company side. Well, let me ask this question. Were they company side or customer side lead replacement, lead service line?
Associated with a WICA project, it would be the company side.
Okay, so if the authority adjudicates the prudency of the WICA projects to date as being prudent and rolls them into base rates, then the answer is there will be company side lead service line replacements being recovered in base rates. I get it.
Yes.
That's correct.
Okay. All right, that's it for me. So it's an appropriate time to take a break, and it's also an appropriate time for the company to consider any redirect for this panel. So can I ask if breaking until 3:30 is appropriate? It's 3:12 right now. Okay, so let's take a break till 3:30, at which point we will allow for redirect of this panel. And then we will move straight into the plant additions panel. We'll probably just start with authority staff cross and not get terribly far today. Okay, thank you.
I got that here, I was like 38. Oh, you would think, oh. Yeah, sick. Oh, outdoors. It's okay. I can, it hurts. And then the coastline in between. No, there was a goal out there, yeah, I was like. You're a redirect. Well, yeah, but. Being in there, like, ever, you know, you gotta put on. Spots for the.
You know what? I appreciate that. You know what? It's actually working out pretty well, doing what you're doing.
So I can start. Oh, that's another thing. Yeah, no, okay, so yeah, see you this thing, yeah. I didn't even make it that far. I didn't really not that long. Yeah, no, it's yeah. Now my knee. That's what I. Here. Oh, yeah. Yeah, so. Just to make sure they work. During transition, you don't have to like. Oh, my gosh, whatever. I don't know why I looked at this. I don't mind. But I think generally the one that'll. One of the lawyers. Just having somebody. We'll definitely talk more. Nice to see you. Yeah. Doing well, thank you. Oh, that was my best friend. Yeah. So. Oh, well, we're going up to do that. So I got the page numbers here. Oh, okay. Yeah, so if you just scroll or, you know, like. But actually, it's funny. Oh, sorry, it's Swin. Yeah, it's Ty. Oh, okay. Yeah, I go by my middle name, Robin. Yeah. Yeah, it's cool. You know, my favorite. Yeah. I don't know how the hell would I know. My daughter, I don't know where she gets that. That's what I hear. That's not the answer. Everything I've ever.
Okay, Attorney Bogan, we'll go back on the record and any redirects, sir. Okay, thank you very much. In that case, we will move directly into our second panel on plant additions, rate base and capital program. And we will start from the top here with a cross-examination from authority staff. I'm sorry, Attorney Bogan, since it's the same witnesses, I'm assuming that we have adopted applicable pre-filed materials, but please correct me if that's, okay, great. Then authority staff can begin. Thanks.
Thank you, Madam Chair. I apologize in advance. I have a bit of a scratchy voice. So good afternoon, everyone. My name is Ryan Paff. I met most of you, I believe, in October at the on-site audit. But today I have a few areas that I want to discuss, mostly related to the company's procurement processes. And so to that end, I've put together a large PDF file that I'll be projecting on the screen. And to facilitate the discussion, I put all of the exhibits that I'm going to use into one PDF file. So hopefully it should be a fairly efficient discussion that we have today. I want to start off by asking you about the company's competitive bidding process. And that's what I've highlighted here on this first page. In response to EOE 50, the company provided as an exhibit to that response a document called Connecticut Water's Process to Pay Narrative, which the company stated was a primary document describing the company's procurement policies and procedures. Is that correct?
Yes, that's correct.
Can you go to page 6? If we go to the process to pay narrative itself, we see the following statement: capital purchases over $50,000 require 3 or more solicited bids unless they meet criteria of the bid waiver. Is that correct?
Yes, that's correct.
Okay. Can we go to page 18? And this was also part of the response to EOE 50, but it is a process to pay flowchart that illustrates the procurement process. And my first question related to this, would this flowchart only be applicable for the capital purchases over $50,000?
The $50,000 threshold is specific to capital work, but the overall process would be similar for operation and maintenance expense.
Okay, but only those expense procurements that cross a certain threshold. It wouldn't be every single.
Correct.
Okay. So based on this flow chart and the process to pay narrative that we just discussed, it appears that there are 2 possible alternatives for the company to use for capital purchases over $50,000. Either the competitive bidding process, wherein the company, as it states here, seeks bids from at least 3 vendors, or a bid waiver. Is that correct?
Yes, that's correct.
Can you go to page 7? In the process to pay narrative, the company states that in lieu of a bid waiver, one may select a vendor from the approved/exempt vendor list. So choosing a vendor from the approved exempt vendor list, is that actually a third option that is not represented on the flow chart?
It would be part of the exception category, and the basis of that exception would be being an approved vendor.
Okay. So looking at how this is written here, it says in lieu of a bid waiver, one may select a vendor from the approved exempt vendor list. And my question is, when we looked at the flow chart and the narrative earlier, it looked like there were two options. Either it was competitively bid or there were a bid waiver. And here it says in lieu of a bid waiver, one can select from the approved exempt vendor list. So it seems like this is a third option. Do you understand my question or my confusion, I guess?
I think I understand, but I think the way to think about it is in the flow chart, the bid waiver description is more broadly talking about any exception from a bid process.
Okay, so the term bid waiver is not used consistently. Would that be accurate?
I agree. It looks like it's not consistent.
Okay. And do you know how often the company's large capital purchases, so those over $50,000, are made through the competitive bidding process versus through a bid waiver?
I don't know the figure offhand. Our large capital projects are generally competitively bid to our general contractor or primary deliverer of the project. We often have smaller contributors to projects who might be awarded work through a bid exception process. Or bid waiver process, to be more consistent.
Do you go to page 88? I would now like to discuss the approved exempt vendor list. And first of all, the word exempt in this context is meant to indicate that these vendors are exempt from the competitive bidding process. Is that correct?
They are eligible to be exempt from the bidding process, correct?
Okay. And the page that we are looking at, let me just get there myself. Page that we were looking at is the company's narrative response to RRU 270, in which the company described the approved vendor list. So I would like to get some additional clarification regarding these categorizations that are used. Starting with the category only vendor. The company notes that it chooses the only vendor categorization for a vendor if there are maintenance purposes for equipment already purchased, unique services with no alternative vendor, such as call before you dig, or local proximity to CWC locations. Or this is a quote, local proximity to CWC locations results in only vendor able to provide a competitive price. Is that correct?
Yes.
So strictly speaking, would you agree that that only the unique services with no alternative vendors, such as call before you dig, are vendors with no alternative?
Can you repeat the question?
So strictly speaking, would you agree that only category 2, the unique services with no alternative vendor, are the vendors with literally no alternative? Would you agree with that?
Yes.
Okay. On the second page of the approved vendor list, which, give me 1 second. We're at 91. So on the second page of the approved vendor list, there's a vendor called Census. And the description states it's the preferred meter vendor. Is this vendor miscategorized?
Potentially, you could call that the maintenance category, category 1. There is no equivalent vendor to Census that maintains the same level of consistency across all our pump stations, which is critical for our operation.
So I'd also like to get some clarification regarding the other categories related to the that are on this listing. So can you describe what the category RFP award indicates?
That would be a vendor who is identified through a request for proposal and was selected through a selection process.
And so if it, can you provide an illustrative example of that and how that would flow through? Because obviously if project were competitively bid, those vendors are selected through a RFP process.
Yeah, there can be different types of RFP processes. An example might be professional services, like design services. We might put a request for proposals for preparing design documents where the respondents provide past project experience, their qualifications, staff capabilities, how they would approach work with Connecticut Water, provide a number of different category of a number of different elements of their delivery approach. And we would review that and make a selection whether they're a qualified vendor or not based on that information. So it would involve an internal review, scoring, and selection process.
And would that RFP process be for the company to, or for the vendor to then be awarded work in the future? Is that how it works for some period of time?
It depends on the specific vendor. The process I'm describing would be qualification for future work or an RFQ type of process. There are certain vendors who would provide ongoing services. I see you have WB Mason, I think, highlighted there as an RFP award. So that would be through a proposal process, a selection, and then that becomes an ongoing supplier going forward for the period of a contract.
Okay. So I'd now like to discuss the differences between the master services agreement and contract on file categories. They appear similar based on the description that we received in RRU 270. Can you distinguish those?
I think they are similar in general. A master services agreement will be a little more broad on general provisions of execution of work that would be subsequently supplemented with a task order that defines specific scopes of work. The contract is likely a little more focused on a specific consistent delivery item that can be defined in that contract, and the contract remains on file for a set term.
Okay. And so how does the company determine whether or not to categorize something as a master services agreement or a contract on file?
I think it's a case-by-case judgment call.
Okay. So we could look at those as essentially equivalent.
I think that's reasonable.
Okay. Are there annual cost escalations included in master service agreements or contracts on file?
And I don't know if I can speak specifically to every contract we have on file. My experience in all master services agreement is they do not include an escalator agreement because they'd be, that the costs would be defined in specific task orders that are attached and refer back to that master services agreement. So the master services agreement itself will define the general terms without the cost for the specific work.
Okay. And are the master services agreement generally just, well, what's the period of time that they cover?
Again, that can vary, but in general, 3 years.
And over those 3 years, is the company agreeing to perform the work at the same cost or, and I guess that was my question, so maybe that was unclear, but are there cost increases embedded in the master services agreement?
There are not in the master services agreement itself. Being awarded a master services agreement with a 3-year term would make that company eligible to be awarded task order assignments during that contract period, where the cost would be proposed and accepted by the company case by case for each task order submitted under that master services agreement.
Okay. So the master services agreement does not include a provision for the cost of the service.
It does not.
Okay. How is the cost set in those situations? Does the company propose a cost for the services and the company reviews it and accepts it or rejects it?
It can depend again on the type of project and the specific circumstance. I think it would be normal that a potential vendor would be contacted and asked to propose on a scope of services that the company defines. They would submit a proposal that would include a fee proposal that would become the basis for a negotiation. We can request multiple proposals from multiple master services agreement holders and select among those. The master services agreement really sets the eligibility for us to have those discussions with potential vendors.
What analysis does the company do to determine that the cost that continuing contractors are charging are reasonable prior to entering into the contract?
For ongoing contracts, we consistently check against the marketplace for items that are material goods that we're purchasing and make sure we're getting reasonable pricing based on the industry. For services, we can work among multiple vendors for multiple different projects. We have a pretty good feel for what is a reasonable hourly rate and number of hours for the different assignments we assign, and we can make a judgment based on that.
So if the company performs that research, is there actually a benefit in having the approved exempt vendor list? Because a benefit would be the efficiency of not having these projects go out for bid, correct?
The benefit is we've established the qualification and come to agreement on the terms associated with work that vendor will execute with us. That's all set on contract. We can move straight to specific task work and a fee proposal, which expedites that process.
Does the company maintain any written documentation in which it formally evaluates the performance of the contractors on the list?
Again, I think that varies by the specific contractor and the specific service we are talking about. There's not a formal process that we apply across all types of vendors.
What would be examples of that process that you would apply to some vendors?
We would do, for example, for designers, at the end of the calendar year, we'll typically convene a group to score and evaluate the performance of the various designers over the previous year for the projects that they worked on, discuss whether they should be identified as potential designers for us in the upcoming year, and assign some rudimentary scoring to different categories of work so that each member of the team is represented and we can see what the combination of those opinions shows for that vendor.
But there's no formal process for doing that for the vendors on the approved exempt vendor list.
Not that I'm aware of.
Okay. You have page 92, Jim. Thanks. I'd now like to switch gears and ask you a few questions about the support you provided for the Hunt water treatment plant. Specifically with regard to the payments that were made to D'Amato Construction. And I'm putting on the screen an excerpt from the company's response to RU 270 Exhibit 2. Specifically, this is page 49 of the exhibit. Can you see that? I was just confirming you could see it.
I'm having a little trouble, so I'm going to
Oh,
look it
okay.
up myself. What page was that again, please?
It was page 49.
All right, thank you.
And can you describe what this sheet represents?
This is a bid tabulation for the bidders on the Hunt Water Treatment Plant project, general contractors.
And in this excerpt, you can see that D'Amato is in the left column, and at the bottom, the total cost for D'Amato is listed as $7,857,078.
Correct.
Can you just you can also see on this page that the president of Connecticut Water signed this document. Do you see that?
Yes.
At the very bottom of the page, there's a statement that both engineering and procurement recommend awarding the Hunt WTP replacement to the low bidder, D'Amato Construction. Do you see the item?
Yes, I do.
We go to the next page. I've included an excerpt that shows that the aggregate payments to D'Amato were basically 8.4 million. And I've provided a calculation at the bottom. It shows that this amount exceeded the quoted price for D'Amato by over 570,000. Do you see that?
Yes.
Can you explain why the company paid D'Amato more than was listed?
Those were scope adjustments, change orders, and potentially changes to those unit price quantities in the base bid.
Okay, so all the price above the initial bid amount, those would have been You can validate those with change orders, et cetera.
Correct. They would all be reflected in a change order.
Okay. Could we get that in a late file?
You can, I'm just thinking if we may have already included that in RRU 270.
I'm not sure. I didn't
Then-
see it,
And
but
let's say yes.
okay.
Okay, so that would be late file exhibit 14, but Mr. Pfaff, can you restate, please?
Can we get the change orders that validate the payments in excess of the not to exceed bid amount for D'Amato Construction?
Thank you.
Okay. Could you go to page 94, please? This is from RRU 270 as well. And it shows that D'Amato Construction was to be substantially complete with its work on January 11th, 2023, and fully complete by May 19th, 2023. Was this extended as part of a change order?
Yes, it would have been extended through the additional scope we requested they complete over the course of the project.
Okay. So the change in the substantially complete date, that will be included in the change orders that you provide?
I don't know if it's specifically called out in the change orders. Regardless, that remains our provision to be able to enforce if we feel like the contractor is not making sufficient progress on a project, regardless of whether the date has been passed or not.
Okay. So would it be accurate to say that the company was entitled to some amount of damages if D'Amato had not completed its work before May 19th, 2023? So I guess I can rephrase the question by saying, was D'Amato complete with the work that it had agreed to do by May 19th, 2023?
The project went in service after May 2023.
Would that be a no then?
Can you repeat the question?
Was D'Amato finished with the work that it agreed to in this agreement prior to or on May 19th, 2023?
No, it was not.
Okay. And can we go to page 95, please? Looking at the payments made to D'Amato and the dates related to the services that D'Amato provided, it appears that the company was working on this project into September of 2023. Is that accurate?
I think the substantial complete date was August 28th.
August 28th. Okay.
Yes.
What do these items under the service tax date represent that go on into September?
two potential things. First, there's a natural lag between invoicing received by a contractor and the date when the work is actually complete. They're eligible for payment upon completion of the work. At that point, they'll prepare a pay application, submit that for review and approval. It goes through our payment process. So there will be naturally several weeks of delay between work being completed and a payment being made. In addition, substantial completion or in service represents beneficial use of the facility for its intended use. There may be small peripheral punch list items that are still to be completed that the contractor would be entitled to payment for after the substantial completion or in service date.
And can you repeat when that date was? I think you just said.
August 28th, 2023.
Good. Could you go to page 96, please? Regarding the company's response to RRU 516, the company stated that it considers final design documents a completed deliverable available for their intended use, which may be placed in service. It then lists 6 applicable projects. Do you remember that response?
I do recall that response.
As I'm sure you recall, the company also provided project cost numbers in Exhibit 8.5 Appendix 1, which I believe was an appendix to your testimony, Mr. Peeling. For one of the projects, specifically project number BU 012364, the Guilford Well Building refurbishment, there's a large discrepancy between the costs listed in the IR response to RRU 516 and those provided in Exhibit A.5 Appendix 1. Specifically in the response to RRU 516, the company listed project number BU 012364 and costs associated with it as $302,555. And then in Exhibit A.5 Appendix 1, it noted the same project as $738,118 in costs. Can you reconcile the difference?
Yeah, I'd say first, the project summary list that you're referencing as Exhibit A5 was prepared in the spirit of sharing as much information as we could about the narrative behind our projects and to provide a way for prudency to be gauged based on what we were submitting. We felt that to truly understand the scope of a project, some costs need to be provided with that. It makes a difference if it's a $10,000 project or $1 million project. Just conceptually, that's very easy to recognize. So we did include costs in Appendix A5. Those costs are a simple spend report for the overall project as of a date in August when we ran a query. So it is not going to reconcile to any of the B schedules or the recovery request. It's simply a total spent on that project. Specifically for the Guilford Well building, what you're seeing there is the fact that that project included some other elements that are not in service and were not part of the design effort. So RRU 516 reflects the cost of the design only, which is the part that we're seeking recovery for.
And so have the other costs, or I should say the other, well, the other cost, for lack of a better word, that comprises the $453,000 difference, have those not been incurred, or are they not being requested in this proceeding?
It's a mix. Some, for simplicity in describing the project, we did bundle some different elements of a project into the single report on Guilford Well. So there's the facility design, but there was also a subsequent lagoon design that was required by DPH. There's a well relocation. There's the connection of that relocated well to our existing treatment facility. So for purposes of narrative, that really fits together as a single project. For purposes of recovery, each of those has their own status as being in service or not.
And how does the company determine what it feels is a capital addition that should be placed in service and sought for recovery in a rate case?
That it's used and useful in providing benefit to the customer.
And these projects that are the 6 projects, these are in the design phase, correct?
These were all completed designs.
Completed designs. And the company is defining completed designs as being used and useful.
Correct. These are 100% complete designs that have either been used for purposes of bidding and awarding a construction contract, submitting drinking water SRF application review and approval, or is already actively in construction.
And so some of these projects, the actual construction hasn't began yet. Hasn't begun yet. Is that correct?
2 of the projects are actively in construction right now.
And then the other 4 have not begun construction?
Correct. 2 are submitted for SRF review and approval to help offset the cost of those projects. One of those is ready to bid and will be going to bid in the first quarter of 2024. And the final one was a pilot study where we have the final report, which will be the basis for design.
And is the company's definition of what is used and useful, is that memorialized in any company document?
I'm not aware of a formal document with the definition.
So how is the individual company employee supposed to know whether or not a project is used and useful?
Although we don't have a formal document, it is a very common discussion item among our teams. And we have manager, supervisor, and director level support reviewing those decisions. In most cases, it's pretty self-evident when a project is fully complete and to the benefit of the customer.
Do you consider a project that has the design phase complete, fully complete?
We considered the design complete. The project itself would not be fully complete, but the design as a project defining document, as a basis for award, is complete and ready to be used for its intended use.
So are there any other Are there any other project milestones, might be the best word, that the company uses to uses as a measure to then say this asset is used and useful other than the design documents?
It would really be only the design documents with the possible exception of redesign work, such as the pilot study we just mentioned a few minutes ago, something that might be a feasibility study or other capital improvement plan that drives the initiation of the project.
So would there be other projects being sought for recovery that are not 100% complete other than the 6 that you provided in RRU 516?
These design efforts are 100% complete. There are no other projects. Everything we've submitted is in service and ready for recovery. I'm not sure if I'm understanding or answering that question correctly.
I guess just like when we looked at these and the projects were through the design phase, but you said that construction on these projects hadn't started, would there be other instances besides these 6 in which the construction of these plants were not complete?
For construction efforts, no, there are no others.
Could you go to page 98, please? Referring to Schedule B-4.0 and Schedule G-1.2, the materials and supplies per these schedules varies. Specifically, the materials and supplies per Schedule B-4.0 is about $8,000 less than the less than what is listed in Schedule G-1.2. It's a relatively small difference, but is there a reason that these do not tie exactly?
Yeah, I'm not sure what the disconnect is between the two of those, but they're both representing inventory as of the end of the test year.
Okay. Give me 1 second. I'm checking through my questions. We went through them more quickly than I anticipated.
Bless you.
Those are all of my questions. So I believe I'm going to turn it now to Ms. Sewell. Thank you.
Just as we transition here, one of the things I was just made aware of, the difference between those accounts. There is a particular account referred to as stores expense that was included in the G schedule here, but not included in the schedule in the B4. So the B4 is just particular chemical and parts inventories, and it's excluding that one account.
Saying the same thing.
I would like to refer you to interrogatory response RRU 67. And also RRU 471, Exhibit 1, that supplemental final that you submitted, I believe, on January 16. So in response to interrogatory RRU 67, the cost of improvements for Miami Beach is listed as $607,651. And now when I went to RRU 471, and I look, actually, there was cost in 2022 associated with this, with Miami Beach purchase. It was $90,041. And then in 2023, between January and September, there were another items, Miami Beach transmission main. This is on line 30, if you have this open, which is $379,571. Then is Miami Beach system purchase that's line 140, which is $89,156. And then is another expense on line 152 for $884. So I added those numbers, including $90,000 from year 2022. And I got the number $469,652, subject to check. And then from October to December, there was on line 26 was cost of $41,492. And then on line 24, I believe 124 was 100. So that's again, Miami Beach system replacement, $128,545. And again, was transmission main for $366,990. So this Miami Beach transmission main is listed twice, once between January and September, and then between October and December. And the cost for October through December is $495,535, subject to check. When I add the cost of improvements for Miami Beach, I got number for $965,187, subject to check. So my question is, in 2022, Connecticut Water estimated that cost of improvements will be $607,651. And now in 2023 is $965,187. Would you please explain, is there an error somewhere, or why is 1/3 of more expense than was assessed 1 year earlier?
I think the challenge here may be trying to interpret the multiple utility plant accounts we have in RRU 471 and the fact we're showing a pro forma through September 30th and then again to the end of the year. I would speculate that maybe some things are being added together when maybe, for example, the October to December period would replace what we had shown for the first 9 months of the year. It's possible the 2022 costs are not being reflected consistently with what we're showing with 2023. So I can't answer your question off the cuff, but we can do a little more detailed reconciliation if that's helpful.
So, okay, so you are looking for transmission main cost recovery of almost $740,000 if I add those two numbers from January through September and October through December. Is this correct? How long was this made? How long was this line?
I don't think that's correct. I think what's happening is the October to December pro forma is updating the cost to reflect actual costs as things were finalized during the fourth quarter. So I do not think those should be added. I think it's an update to what was originally shown.
Well,
So for example, in column G of the October to December 2023 tab, that's listed as the estimate that we provided back in RRU 279 for what we thought the costs would be through the fourth quarter. And then we have the update adjacent to that at 366,990 in column I and K. So those wouldn't be, not that that's specifically what you're talking about, but those wouldn't be added. That's a supplement, an update to what was originally provided. And we're showing the original figure as reference to show what the departure was.
You're talking about pro forma, but you submitted actual numbers. One time it was on January 12th, and then you submitted supplemental on January 16th. So aren't those the accurate numbers for this project?
The significance of the January 12th or the January 16th, the last date you saw, allowed sufficient time for us to do a full accounting close of calendar year 2023 through December 31st for actual costs through 2023. Prior to that, there was always some uncertainty that there might be some accounting adjustment or some final cost that would be assigned to the job, but this shows the final figure as of that date, December 31st.
May I ask for late file?
Of course, please. We are up to late file exhibit 15.
Miami Beach actual cost of improvements as of January 12th of 2024. 24.
As of January 12th.
Because this project, I believe that is complete, correct?
Correct.
Chairman Gillette, if I may.
Please.
Inquire, Ms. Schul, were you also looking for a reconciliation or an explanation of the difference between the cost reflected in 2022 and 2023, or no?
This would be nice if you have.
Since you're asking.
We will endeavor to do so. Thank
So
you.
can I restate that just to make sure I'm understanding? We're talking the total Miami Beach cost of 607 that you referenced, or, and then a breakdown of what the contributing costs were to that by transmission main project, connection project, each of our efforts in that overall budget item?
Yes, breakdown, please.
Okay.
Each item. In your response to interrogatory RRU 471 supplemental to 279 Exhibit 2 and in others, also the company is using word for status as a standing. Would you please explain what this means?
The status of standing is used for projects that are a standing budget item for us. The reason we use that designation here was more applicable earlier in the year to represent the fact that those budget items are uncertain on the utilization through the course of the year because they generally cover a category of work that's predictable but uncertain, like water main break repairs. When we presented these costs, we wanted to reflect the fact that we had in-service tasks under that budget item, but although it's reflected as in-service, there could be additional costs in the fourth quarter of the year as additional small items go in service under that same budget item. That's unique to the standing budget items. So that designation is just to help call attention to that fact.
Okay, thank you. In response to interrogatory 68, RRU 68, the company is talking about Williams water treatment plant, drying bed phase, and Edgewater Estate water treatment plant. Is the Williams water treatment plant drying bed complete?
The Williams water treatment plant, including the drying bed phase, is in service as of 12/31/23.
So it's used and useful, correct?
Correct.
What about the Edgewater?
That is not complete. That is not used and useful. There were some delays completing that, so that is not part of our most recent update of RRU 471.
So this project's supposed to be complete by February 15, if I remember correctly.
It's uncertain at this point. It's very close, but we're not ready to put a date on it right now.
But this means it will not be complete by the date of close of records, February 9.
I no longer expect it to be complete for close of record.
Okay. There was a discussion about vendors. In response to interrogatory RRU 89, I am interested, how do you select contractors?
How do we select contractors as
To do certain jobs.
we would normally, for a specific job, we would go through the bid selection process like we discussed previously. Is that the question, or just in general, how we identify who we're going to invite to bid?
My understanding is that you have a list of contractors. How the contractors get on your list, and then how do you select them from your list? Or maybe sometimes do you go outside of the list, and what would be the reason for that?
If a contractor is interested in joining our bidding list, they need to submit a qualification package to us documenting experience with similar scopes of work, successful completion of projects, references that we can check, safety record, insurance record, all of that is part of our evaluation process. If we review that and consider them to meet the standard we expect, we can add them as a provisional temporary approval. Typically, that would set them up to be awarded at least one or be eligible to bid on smaller projects, at which point if they are the successful bidder on one of those projects, we can gauge their actual performance and determine if they belong on our bidders list long-term. And that works in reverse as well, that underperforming contractors can be removed from our approved list for failure to perform up to expectations. We're generally looking to expand our list so that we foster as much competition as possible. So we do routinely meet with contractors and receive applications to be added to our vendor list.
How is the company reviewing credential of those contractors?
It's a team of the engineering group and the procurement group evaluating different aspects of the submittal. So we give them some direction on what we require as part of that application package. And the team reviews, chases down to confirm things like references and licensing and reviews the safety manual. It's a team that will look at different aspects of that and come together to make a recommendation on whether they belong as an approved vendor.
Okay, thank you. Now we will go to response to interrogatory 471. Let's start with October, December list.
All right, I'm ready.
Okay, there was a discussion about Miami Beach wells assessment. That's on line 26, should be.
Yes, I see it.
Would you explain what is included in the assessment? Wells assessment.
I would have to check. I don't know specifically the scope of that item.
How the wells assessment contributes to completion of the project?
My speculation would be that our intention was to make use of the existing sources at Miami Beach. There were those contamination issues I mentioned associated with those wells. Department of Public Health was requiring upgrades to the wells to make them viable and permittable for use. Assessments likely here is referring to consultant and contractor support we had to evaluate the casings, the caps, the structure of the well itself, and make the necessary repairs so that those wells would be available for use. And that's part of the overall strategic plan for Miami Beach, was to activate those wells, construct the transmission main, bring that source back to the Soundview treatment facility where it would get the 4-log treatment and become available supply for that system. So that's a necessary element of the overall implementation of the Miami Beach upgrades.
But those wells are not used by your customers right now, are they?
They are now connected to our Soundview treatment plant and treated there and distributed to the Soundview system.
So it's used and useful. The project is complete.
Correct.
100%.
Correct.
Okay. Would you please talk about the historian and enlargement project that's on line 49? Enhancement, I'm sorry, historian enhancement project.
Yep, I see it.
Indicate what you would ask Mr. Peeling to speak to on that project.
I would like to know, it's very interesting, the title, historian enhancement. What is this project all about and how it contributes to well-being of your customers who are paying for water, for treatment?
It is a good name, isn't it? What that's referring to is Historian is the database that stores our operational data, water treatment plant operation, pump station operation. The data is stored in that system. The enhancements project improved our ability to utilize that data to show our treatment plants are in compliance on a continuous basis with regulatory requirements, and just improve that database accessibility and usefulness. So it benefits customers in helping assure accessibility to operational data and applying that data to a compliant water supply.
Okay. Next one is line 66. And this is Saybrook Booster Pumps improvements. And I see that is this pump improvements is not in service. Is this correct?
That's correct.
So the $10,000 that you estimated it will cost you, you are not seeking cost recovery for this.
That's correct. We kept this line in the table for consistency, but you can see the $10,000 in column G has been zeroed out in column I and K since it's not in service as of December 31st.
Okay. Line 71, please. Engineering preliminary investigation. What is included there? And you are asking for recovery of $31,385.
Subject to check. This is a standing budget item, so this is another one that has individual task items under it. I'm fairly certain this is related to a shoring system that was installed at the Ashford Park pump station. We had structural issues cracking in the foundation, the walls showing signs of moving inward into the station. This was a project to set up some shoring against any deterioration of that situation while we evaluate a potential long-term solution there.
How the preliminary investigation contributes to completeness of the project?
I think it's miscategorized under the preliminary investigations. And I would say bear in mind that that's a title for a standing budget item. So we earmark budget under that budget item for individual tasks that come up. Typically, those would be preliminary investigations that we transfer to an active project as the project takes shape. This would be very early in the process. Since this was a quick turnaround project that needed quick implementation, it looks to me like the project was open under this, never transferred to another budget item, so it went in service as a work order under this general budget item. So what the customer benefit is that shoring system that's now securing the station.
Are you saying that this money was used for securing the foundation of the building?
To install a shoring system, angles to help prevent any further deterioration of that facility while we evaluate long-term solutions to address that issue. So it began as a preliminary investigation of what do we do about it. It quickly evolved into we better get some shoring in place. It looks like that was charged to this same work order and was used and useful when that shoring system was complete in protecting the station.
Is this project complete?
It is.
There are some projects listed number of times, and one of them that caught my eye was project, I believe, on line 57, 78, 92, and is rettich slash waste combined treatment. So it's RETTIH, HCH. So why this project is listed number of times on this list and the cost is not combined as a one cost?
This list is organized to show utility plant accounts for each project, so it's not rolling those costs up into the overall project total. So if you notice line 57, or excuse me,
Yeah, that's
the
line
first line,
57.
so if you look at column D, that identifies what the utility plant account is. So this was the pilot study we discussed earlier. So that project had a couple different elements that are recorded in our as-built system when the project's complete. A portion of that was water treatment plant equipment, which is represented on line 92. A portion of it was electrical pump equipment, that's $1,000 on line 57. And then we had structures and improvements for the balance on line 78. So the combination of those three represents the total project cost. This just splits it up by utility plant account to help show how that money was spent.
Yeah, if you think of the last two tabs of the workbook, those are the B schedules that make it into the case in terms of the revenue requirement. So we can't take the project list and bring it into the case. We have to sort everything by the account numbers so that we get the depreciation right and all the other pieces. So that's why it has to be separated here so that we can translate it into those B schedules.
Okay. Now, we talk a lot about lead and copper in this room today. There is on line 135 and line 155, lead copper rule revision. My question is, you haven't complete the projects, you haven't removed lead or copper from service lines. And why are you asking for cost recovery here? This project is not complete.
I think this project refers specifically to the inventory project.
It does refer to the inventory, and this was the, it does refer to the inventory, and this was the first phase of that. So as part of that project, we identified what we do know and what we don't know. So now we're moving into the next phase where we're working on identifying more of those unknowns as we move forward. But that initial first step of looking at our inventory, looking at the data we have, scrubbing the data, and having that initial set of those knowns and unknowns.
All right, but on line 155, it seems like you are asking for recovery of $524,688, and you're saying that this is in service.
Yes, it is in service.
What is in service? It's just preliminary investigation.
that identifying that inventory is that piece that's in service. So now we can take what we know from there and then further identify those knowns and the unknowns. We know how many existing lead services we have. And we know what the other materials are that we know, and we also know, we also have those unknowns established. So the next phase, that is the initial phase of the project. The next phase is to move forward with continuing to identify the unknowns and developing that plan for how we are going to address the unknowns and the lead service lines. It was just the first phase of the project. So the first phase is complete, and now we're continuing to identify those unknowns because we have some additional time before we are required to submit those. So we wanted to continue to evaluate that, but this is that next phase in identifying what we don't know and how our plan to do that.
The deliverable on this project is a report that functions essentially like a capital improvement plan.
But so far, customers are not benefiting from the project. The project needs to be complete. Lead service lines or lead must be removed from the system. Then we can say that customers benefit from the project and is 100% complete. This is just one phase of the project, correct?
This is a planning phase for developing a full construction effort that's appropriate for the need at hand.
And I do believe that the customers benefit by knowing where there is lead and where there is not lead.
All right, thank you. Regarding Hunt water treatment plant upgrades. The cost estimate was $242,063. And actual cost is $359,740. Would you please explain the increase in cost?
Can you point me to?
That's
what you're referring to?
RRU 471, Exhibit 1, supplemental.
And what line is this? It's for the Hunt water treatment plant?
Yes. This is line 70. It will be line 70.
All right, thank you, I have it.
So the estimate was $242,063 and actual cost was $359,740. Would you explain why is so much more the actual cost?
I'm sorry, I think I did not have it. Are we looking at the October, December tab?
This won't be December. I believe this is January through September. Is 471 Exhibit 1 supplemental.
Okay, I see it, thank you. So the difference in that category, I would have to look deeper. I'm speculating a little bit. That scale of difference is either due to recategorization of some of the utility plant account information that Hunt water treatment plant shows up in other line items in this schedule, or it could be some trailing costs for that project from the in-service date. So during the procurement discussion, we talked about the invoicing trailing behind in the August 28th in-service date. So it's realistic that we would have some additional costs arriving in the fourth quarter that would reflect an increase in actual cost during the fourth quarter versus our initial estimate of what we thought it would be. That would again be a situation where our forecast for what would occur in the fourth quarter underestimated what the actual costs would be that arrived in the fourth quarter. So that's an invoicing. Again, our initial estimate there for 279 was based on a forecast for completion date and final costs. This is just additional invoicing or costs that came in the fourth quarter.
I'm sorry, it's hard to see it because I prepared this before and now I don't see, I have this highlighted. This is revised 9:30 performance. The first one. Final revised. Is this final revised? Oh, it needs to be final revised. We don't have revised. Hang on. Okay, so we will go without it.
I think you're there. It's just the next tab. Yeah, row 129.
All right, so now I am in the right place. On line 129. This is mains. Estimate was $482,133. And then actual is $765,112. Do you see it?
Yes.
So would you please explain why such a big difference between estimate and actual dollars?
This item captures contributed plant from developers, and that work is unpredictable, what projects are going to come in and what time they're going to occur. So clearly, there was more developer work in the fourth quarter than our initial estimate assumed.
Connecticut Water, as a company, don't you think that you should have better control over what the developer does and what you can do, so you don't have such a big difference between what is estimated as a project and what is really, what cost you?
This is contributed plant, so the costs are on the developer. And we're left to estimate based on what we think is a reasonable level of work based on past experience. Am I misstating that?
Okay, so let's go to the next line, 130. It's in 130 that service renewals, all regions. An
Yes.
estimate was $482,133, and then actual plan was $765,112.
For service renewals on line 130,
130, yeah.
the difference on that is again, the service renewals.
Oh, I'm
budget item.
sorry, I misspoke. It was estimated was 100,000, and then actual is $280,392.
Correct. And this is another standing budget item where we know service renewals are going to be required. We reserve some amount of capital budget to account for that likelihood and expectation, but the actual number that we're going to need to replace over the course of the year is dependent on what fails or what circumstances we encounter over the course of the year. So the $100,000 that was estimated for the end of the year was the original budget amount set on just an informed guess at what level of service replacement we required in 2023. And the actual requirements for that were $280,000. So significantly more service line replacement or service renewals. But it's difficult to program for that upfront because that is mostly a reactive budget item.
Okay, so if we go back to line 116, I will go to line 116. The estimate cost was 20,369, and actual cost was 165,680.
Correct. This is the interconnection project that was roughly $6 million overall and went into service. I think it was August of 2023. So this would represent just the fourth quarter costs of that project, which were slightly higher than the forecast amount for a project of that scale.
All right. Chairman, I have probably for another half an hour question, or maybe 45 minutes.
Okay, you know what, I think we've put in a solid first day, so I'm gonna call it here. And we'll pick up in the morning with Ms. Schul's remaining cross. I'm showing 2 read-ins that we have not covered, read-in E and read-in F. So maybe we can check in first thing tomorrow morning and see where we're at with those. And I'll just ask everyone, to be prepared with any administrative matters before we get started. Otherwise, we're going to get right smack back into cross. And we do start at 10 a.m. tomorrow. The authority's regular meeting is being held at a special time of 9 a.m. so we can get right into the hearing. So I want to thank everyone. Reminder to our witnesses that you'll remain under oath when you return to see us in the morning. Unless there are any administrative matters before we close for the evening, then we will see everyone back here at 10 a.m. Thank you.